May 24, 2022. Police respond to a school shooting at Robb Elementary in Uvalde, Texas. Video released of the response garnered outrage when police took 77 minutes to kill the gunman.
Mr. Ramos, can you hear me? Please put your gun down, sir. Please don't hurt anyone else.
The shooter entered Robb Elementary at 11:33 a.m. 3 minutes later, 11 law enforcement officers arrived inside. Officers at several points delayed gaining access to the room by clearing other classrooms and negotiating with the shooter. After 50 minutes, a team begins to move towards the classroom. A little over 20 minutes later, rapid gunfire, and the gunman is killed.
I just don't know what was going through those policemen's minds that tragic day, but everything said, there was just no action.
19 students and 2 teachers were killed by the gunman, and 17 survivors were hurt.
Somebody's error was made there, and they gotta pay for that error, because we're paying it for the rest of our lives, not seeing our kids grow up.
Nearly 400 officers waited before confronting the 18-year-old gunman, and only 2 officers have been charged. One of the 2 senior officers in charge is now going to trial for the failures of that tragic day. Former school officer Adrian Gonzales faces 29 counts of abandoning and endangering a child. If convicted of all charges, he could face up to 58 years in prison. Gonzales pleaded not guilty to the charges, and a judge granted his request for a change of venue for the trial. Defense attorney Nico LaHood said, quote, "It would be impossible to gather a jury that would not view the evidence through their own pain and grief."
I think in this case, it was just negligence. Who waits 77 minutes outside? Who does that? Because I guarantee if it was their children, they would have ran in. And that's just all there is to it. They failed us. They failed our kids. They failed our city. They failed our community.
Soon after, we received the news that our daughter was among the 19 students and 2 teachers that died as a result of gun violence. We don't want you to think of Lexi as just a number. She was intelligent, compassionate, and athletic. We stand for Lexi, and as her voice, we demand action.
In response to the shooting, the Texas Senate passed the Uvalde Strong School Safety Act, improving the way police deal with active shooters.
This jury if they don't find a verdict one way or the other. So we could see possibly this judge at some point having to invoke an Allen charge. And so for our viewers that don't know that, I would ask our expert to explain what the Allen charge is, because that is a strong possibility in this case as well.
I think that it is possible that the judge will have to Allen charge this jury. Essentially, an Allen charge is to say, hey, listen, the jury comes and says, we can't reach a verdict, right? We can't agree back there. And so now we're deadlocked and we want to stop deliberating. And before a court will accept that a jury cannot reach a decision, they will give the jury language and instructions that say, okay, look, these facts aren't going to change. This testimony isn't going to change. If we have to do this all over again, that's going to be a problem for everybody. So we really are going to ask you to go back and really search your conscience and really re-examine the evidence that was presented to you and try to reach a verdict, because nothing about what was presented to you is going to change in front of a different jury. So Allen charges are pretty common in sort of either high profile or difficult factual cases, because it's hard. It's hard for juries to make decisions about things like this. And oftentimes I think it's natural for a person to say, I can't do it. Like, I thought I could. I know that the state and the defense did a good job trying to pick me as a juror, but I can't do it at the end of the day. And so courts really say, no. I mean, the next person's not going to be different than you. They're going to hear the same things, and it's going to be just as hard. So really try.
Well, Rebecca, we're going to let you go so you can go into court. I'm sorry, my voice is really funny today. But we'll be looking forward to closing arguments. Thank you, Rebecca, for joining us.
Thanks, Rebecca.
Okay, so bear with me, folks.
Okay. I can hear you.
We were talking about concurrent foundation.
Yeah.
Because the judge allowed that charge in. They were talking about, the defense was saying, well, we want it in because, the shooter's actions, the door locks, all that kind of stuff. Can you explain to folks what a concurrent foundation is and why that's important?
Okay, so interestingly, Tanya, it's kind of uncommon in criminal cases, right? Because it's really talking about like the synergistic effect between like the defendant's actions or inaction in this case, plus something else can make it so that the defendant is still responsible or criminally liable for whatever the circumstances are. And so it essentially says, hey, jury, you can look at all of the facts and circumstances as it relates to Adrian Gonzales and his action or lack thereof, combine that with door locks or whatever other evidence or factors, you find to be relevant. You can combine those things and you can still say that at the end of the day, the defendant's actions are criminal.
Why do you think the judge allowed it in?
I think that there was, I think a judge does have a responsibility to do everything that they can to kind of protect the record, right? Everything that they can to try to say, if this person is found guilty, there will be an appeal. I want to make sure that I haven't said no to anything wrong. You know what I mean? And I've let everything in that could level this playing field or give the jury as much as they possibly can to be able to make a decision. And so I think in this instance, the court said, okay, yeah, we did hear evidence of some other factors that could have been, contributory in terms of Adrian Gonzales. And so I don't know that I have a reason to keep it out. It's not completely unheard of. And right. So why not err on the side of caution, knowing that I'm trying to protect this record and let it in?
Well, and we have a lot of unusual things about this trial. It's funny, the longer I don't talk, the harder it is to talk.
Okay, so that's okay.
So yeah, we're get my voice going.
Okay, there we go.
So it's like, the other thing I want to bring up is, so the judge also, in the charge, is that the discussion of the whole duty to act, that he had a duty, and the defense objected to that. Why is it important for that to be in? And that's the discussion we were having. That during the trial, I don't know that they were required to present that type of evidence, but it feels like it would have been helpful for the jury to hear it.
Especially because it sounds like they touched on it in jury selection, right? And so it's weird, that, but remember, so the way that the law is written is it's act or failure to act or omission. Right. And you can charge that as an and, like you acted and you failed to act, or you can charge it as and you can prove it in the or, right? You acted or you failed to act. And so I think that a sort of a correct jury charge is going to include the duty to act because that's included in the statute, right? But you don't have to say, okay, I have to prove this element beyond a reasonable doubt. You can say this is a part of the statute. I can prove it beyond a reasonable doubt, or I can prove, the failure to act on that duty.
Yeah. And the other thing, the prosecution went 9 days, or not total
right,
9 days,
with
but
breaks
into the 9th day. That seems like an extraordinary amount of time. I mean, I've watched really high-profile murder trials
that don't take that long.
What does that tell you?
That tells me that the prosecution's case is weak. I don't want to ever take away from the extreme trauma that the families, that everybody went through in this experience. But that is a separate issue from the criminal allegation against Adrian Gonzales. And so when you start to see prosecutors putting on, witness after witness saying the same thing over and over again, and there's not a whole lot of nuance, and they're dragging it out. I mean, I think that it's sort of just, sort of evidence that they're really trying to piece together something that is not as strong as they would like.
And somebody else was asking if you could re-explain the Allen charge and what that is. I saw that in the comments.
Okay, so, and I mean, obviously, as I'm explaining it, I'm not necessarily using the exact Allen charges have very specific language that will go back, be read out loud to a jury, and they will be given a copy of it to go back and read it. But an Allen charge happens at the point where a jury sends a note out to the court or to the judge to say, Judge, we are deadlocked. We have looked at all of the evidence. We have had, very intense discussion, and there's not anything that we can agree on in terms of guilt or not guilt in this case. Sometimes you see Allen charges when juries go back and they've deliberated for 2 hours, but the trial lasted 9 days, right? They're going to say, well, there's no way that you had meaningful discussion. But at the same time, the court can't force a jury or a individual jury member to go against their own conscience, right? And you can't tell a jury, hey, compromise, right? Like that's totally against the principles and the tenets of, sort of our jurisprudence. And so an Allen charge just says, hey, listen, like, again, the facts are what they are. Whatever is presented to you is going to be presented to the next jury. Nothing is going to be different. So please go back, try to have further discussion, try to hash this out, because if we have to do it again, we can't do this in perpetuity. We can't just, pick juries forever. You know what I mean? And so we're going to ask you to really try hard. And obviously, if a jury comes back and says, okay, we tried again, we talked about it again, there are people that are immovable. There's, we're not going to go against sort of our duty and compromise or draw straws, or, you know what I mean? And so an Allen charge just says, hey, jury, please, are you sure that you did everything that you could to try to reach a verdict here?
Well, and we're actually hearing that court's been delayed. It was supposed to start at 9.
Oh.
Well, actually, we had been told yesterday that at 8:30 they were going to approve the charge,
Yes.
because they had gone over it.
Mm-hmm.
And so apparently we're delayed. We don't know why. But court is court.
Court is court.
And court moves on court time.
Right, court
does not move on our time.
Right.
How likely do you think it is that we could see an Allen charge?
I think that it's possible. I think that my prediction is that the jury is probably, and I think, you and I were talking about this, Tanya, it's possible that a jury is going to look at everything through the course of as they begin to deliberate, however many hours that may be. I think that they might reach a verdict, but choose not to come back to the court today, because they want to make sure that in their heart of hearts, right, that they feel very good about the decision that they're making. I think that they're going to sleep on it, and I think they're going to come back in the morning. I don't think that this jury is going to struggle to make a decision, right? So again, we're talking about Allen charges because a jury is saying we cannot make a decision. I think you're going to have strong jurors back there that are going to say, guys, this was emotional. I mean, we were crying as we were listening. We saw horrific pictures, but we've got to set that aside because we have a job to do. And I know that if in every jury trial, you work hard, especially as a defense attorney, to get that one juror that's really strong, that's going to be really vocal and say, but we have a duty. I know it's hard, but we can do this. And to really guide the jury into making a decision, not influencing anyone, but guide the jury to say the emotional aspect of this is not our job.
Do you think that, let me ask you this. So each side's been given an hour and a half for closings. And then we're hearing that maybe they'll try to go up to 2. That sounds like a really long time.
I know. And I think that you lose your jurors. Like if you're just talking and talking and talking, and I worry that in this particular case, the prosecution might kind of talk in circles a little bit. And I worry that they really will lose the jury and all of that. But I think that when you're just going and going and going, I don't know that I mean, I get that it was 9 days, but I don't know that there was a whole lot of like, we need to rehash enough information that we can just talk for 2 hours. Now, I think they're going to do the diagrams and they're going to, show where people were standing, and they're going to, I think they're going to, I don't know how dramatic they're going to get, but in terms of showing some of the crime scene photos and things like that. But I don't know, Tanya. I mean, I think an hour and a half is more than sufficient.
That's a long time. I mean, I've watched cases where it's like, big cases where it's like 45 minutes.
Yes.
Maybe an hour, but an hour and a half, and even talking about going 2 hours, I was like, holy cow, which is why you got to have a break at some point.
You got to have a break. There's no way that a jury can sit there for what could be 4 hours and just listen. You're not even going to process what you're hearing. You're not even going to be able to digest it. And I think that it would do a disservice to both sides, right, if there wasn't some kind of break. But then the question becomes, when would the break be? Right? Because the state opens the argument, right? And in between, now the state could waive. The state could waive and say, okay, we're going to let the defense go, have their entire time, and then we're going to close the argument and have our entire time. But if the state doesn't waive, then where do you put the break?
Right.
Because it almost feels like if the state opens, then the defense does their entire hour and a half, 2 hours, and then you take a break, and then the state gets to close for another 45 minutes potentially. I don't know. That doesn't seem, I don't know. That seems like almost, putting your thumbs on the scale a little bit, because
it's like there's no good answers.
There's no good answer. And maybe they're going to reach an agreement. Maybe part of why we're delayed is because they're all kind of talking in chambers to say, okay, we have to have a break. Hey, state, will you, waive your opening and just let the defense go right into it, and then we'll take our break after that, and then you close.
How much do you think it's going to play into it for this jury that Adrian Gonzales, I'm going to bring up a few things.
Okay.
One, that there was an officer with an AR-15 or with a rifle who could have taken the shot. That Adrian Gonzales does not have line of sight, and that is undisputed. He arrives on the south side. The shooter is the officers that arrive on the west side, actually. That's Coronado, Saucedo, and Mendoza. Saucedo has a rifle. Could have taken the shot. Doesn't take the shot, for whatever reason. And it is chaotic.
It's chaotic.
Adrian Gonzales, he does go in. The prosecution's contention is, well, he didn't go in fast enough. He waited for backup. They make it sound like he gets there and he just stands there. Mm-hmm. But the evidence really is that he gets there and he responds to the crash. He gets there. He drives up onto the school grounds. He sees Melody Flores. Yeah. He doesn't really know who she is. Mm-hmm. And then she's hysterical, rightfully so. She thinks she's been shot. She hasn't been shot.
Right.
But when other officers get there, he does go in. He's part of that group of officers that goes down the hallway. Mm-hmm. And he also, and later on, helps pull children from the school. How much does all of that play into the jury's calculus?
Well, and I'm okay, Tanya. You're rubbing off on me with this cough.
You already had it when you got here.
I did. I admitted it. How does it not play into the jury's calculus? But really, that plays directly into the concurrent causation, right? That we talked about earlier. That this officer that had that rifle, that had the shot, that didn't take it, and was under direct command of Adrian Gonzales, is that the second factor that makes Adrian Gonzales guilty of this, of what he's charged with, right? That obviously is that's a huge factor. And I think that if a jury says, you have this officer that's standing there, he has a shot, he doesn't take it. Does he not take it because Adrian Gonzales hadn't given the order?
Adrian's on the other side of the building.
So he doesn't know.
No. And
so how does that factor in, right? Does he, because, does this officer have the duty to say, hey, right, I'm going to do this. I'm going to, sort of do whatever I can to try to stop stop this threat, regardless of what anybody else knows, regardless of any order that I've been given or not given. Just, and so I think that it's a huge factor. And I think that if I'm a juror, I'm saying his inaction, the officer that had the rifle and the shot, his inaction is not attributable to Adrian Gonzales.
Right. And I feel like it's, I think what we heard over 9 days is this was a really complicated, this was a chaotic situation. You have the other unusual factor is that there's no other school shooting, mass shooting that I'm aware of that begins with a car crash.
Not that I'm aware of, no.
It's really unusual. And then you had that the apparently bailouts were common near this school.
Right, which I thought was, I've never heard of that.
It's kind of wild.
Yeah.
That it was common for there to be high-speed chases and people to bail out. And so there was this kind of culture of like,
okay,
well, there's
here
another
we go
bailout.
Again.
And then they also had this culture of not locking doors.
Right.
The exterior door is not locked. And the teachers, the school principals there had given out
the magnets.
Like these to defeat the locks. Now that's not why room 111 was open. Room 111 had an issue with the door latch.
Right.
Room 112 was locked. But the door between the classrooms was unlocked. And so there's all these extenuating circumstances.
Right.
And the jury heard all of them.
Right. And so how can you say with all of that, with the bailouts, with the sort of everyone is kind of desensitized to like issues and drama, do you know what I mean? Or scary situations because they're having these bailouts. You have a car crash. You have doors that are being propped open. You have unlocked doors. You have, we don't have the resources to be able to have key fobs. So we have these magnets. We don't lock doors in between. I mean, how do you say that any of that was solely attributable to Adrian Gonzales? Like, right? So right. I don't know how you can say that all of the things that went wrong that day that didn't contribute to the tragedy that occurred. And the sheer number of law enforcement that was there. How do you have any direction? How do you have any, who's in charge? Who's calling, the shots? Who's telling us where we're supposed to? I mean, I don't know of a mass shooting where like sort of that early on, you have that number of officers on scene. Nobody knows what anybody else is doing. Half of them didn't know what department the other people were from. I mean,
it was a wild situation out there.
Yes.
I mean, you had, as the situation wore on, you had, I forget the exact number, well over 300 officers out there.
I think it was like 372.
It was a lot.
Yes.
And it was an extraordinary situation. And, I've covered law enforcement for 30 years. After Columbine, there was a sea change
right.
in how mass shootings were handled. There was a recognition that an active shooter has one goal and one goal alone, and that is to kill as many people as they can,
yes.
as quickly as they can.
Yes.
And you don't wait.
You don't wait.
And so, but Adrian Gonzales, he does respond. And I think it's going to come down to, he does respond. Maybe you don't. I guess the question is, does it boil down to maybe we don't like that he didn't do this or that, but is it criminal?
Right? That's the question, right? And I don't want to necessarily characterize this in a really offensive or crude way, but, if his inaction was rooted in like not knowing, coupled with fear, coupled with, maybe a little bit of, sort of deer in a headlight type of situation, do we criminalize human, responses to things that we've never experienced. Do we criminalize that, right? Like, as a defense attorney and even as a prosecutor, you in jury selection, for example, you talk to jurors about not everybody responds the exact same way. So then if not everybody responds in the same way to some traumatic event or some experience that nobody has ever had, can we criminalize how they respond to it? And that's what I think is happening. I think they're criminalizing it. Oh, I see, Judge.
Okay, so we've got the judge. Okay, we're gonna go listen to court. Sorry, guys.
I wonder if we're going to hear why they were delayed.
You can be seated in the courtroom. Thank you. All right, good morning, members of the jury. We have finalized the charge of the court. I'm going to read it to you. You don't need to memorize anything. You will have a copy of it, and it'll be in the jury room during your deliberations to consult. After I complete my reading of the charge, both sides will argue the case, and then we will ask you to deliberate. This is cause number 25 FC 0001U. State of Texas versus Adrian Gonzales, charge of the court, members of the jury. The defendant, Adrian Gonzales, is accused of 29 counts of endangering a child. The defendant has pleaded not guilty. You have heard all of the evidence that will be admitted as to whether the defendant has been proven to be guilty of these offenses in violation of the Texas Penal Code. Both sides will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether the defendant has been proven to be guilty or not. You will have a written copy of these instructions to take with you and to use during your deliberations. First, and I will note, ladies and gentlemen, the notes you've taken throughout the trial, the bailiff will hold those for you until after the deliberations are complete. As I told you, if we have a dispute as to anything regarding the evidence, we're going to rely on the official court record, so the notes will be retained during your deliberations. First, I will inform you of the general principles of law that must govern your decision in the case. Then I will inform you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles, the indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant may have been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his innocence or to produce any evidence at all unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After a careful and impartial consideration of all of the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish the guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt as to whether the defendant is guilty, you must find the defendant not guilty. Jury as the fact finder. As the jurors, you must review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law as provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only the evidence to reach your decision. You must not consider, discuss, nor mention anything that is not in evidence in the trial. You must not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by lawyers are not evidence. Evidence consists of the testimony of the witnesses, materials, and physical items that were admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are to be given special meanings. In that case, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and the evidence that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based upon the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice or sympathy. You are admitted exhibits. You will be provided all of the admitted exhibits for your examination in the jury room. Testimony, the court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson or presiding juror, number one, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and number two, identifies the name of the witness who made the statement. The verdict, the law requires that you must render a verdict of either guilty or not guilty. The verdict of not guilty simply means the state's evidence did not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on the verdict. When you reach a verdict, the foreman or presiding juror should notify the court. The defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf if he elects to do so. The defendant may also choose not to testify. The defendant's decision not to testify cannot and must not be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Instructions on count one, endangering a child. Excuse me. Accusation. The state accuses the defendant of having committed the offense of count one, endangering a child. Specifically, the accusation is that the defendant, as a peace officer for the Uvalde Consolidated Independent School District, by omission, intentionally, knowingly, recklessly, or with criminal negligence, placed Jose Manuel Flores Jr., a child younger than 15 years of age, in imminent danger of death, serious bodily injury, or physical or mental impairment by engaging in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness one and having the time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, and delay the shooter, or failed to otherwise act in a way to impede the shooter until the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112. B, after hearing gunshots and after being advised of the general location of the shooter by witness one and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 and 112 of Robb Elementary School. And that as a peace officer for the Uvalde Consolidated Independent School District, the defendant had statutory duties to act as follows: to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater, or after being informed in any manner that a threat had been made by one person to do some injury to another person, to prevent the threatened injury if within his power, or to protect the safety and welfare of the people in the jurisdiction of his school district, and that the defendant did not voluntarily deliver to Jose Manuel Flores Jr. to a designated emergency infant care provider. Relevant statutes. A person commits the offense of endangering a child if he intentionally, knowingly, recklessly, or with criminal negligence by omission engages in conduct that places a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. A person commits an offense by omission only if the person has a duty to act. A peace officer has a duty, A, under the provisions of Article 6.06 of the Texas Code of Criminal Procedure, to prevent an offense against a person about to be committed in his presence and use as much force as necessary to prevent the commission of the offense and no greater. B, under the provisions of Article 6.05 of the Texas Code of Criminal Procedure, after being informed in any manner that a threat has been made by one person to do some injury to another person, to prevent the threatened injury if within his power. C, under Section 337.081 of the Texas Education Code, to protect the safety and welfare of people in his jurisdiction. Such endangerment is not an offense if the defendant voluntarily delivered the child to a designated emergency infant care provider under Section 262.302 of the Texas Family Code. Definitions: conduct, an act or omission and its accompanying mental state. Omission, a failure to act. A person commits an offense only if he voluntarily engages in conduct, including an act, an omission, or possession. A person who omits to perform an act does not commit an offense under the law, unless a law provides that the omission is an offense or otherwise provides that he has a duty to perform the act. Intentional conduct, a person acts intentionally as required by this offense if the person has the conscious objective or desire to engage in the conduct that would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Knowing conduct, a person acts knowingly as required by this offense if the person was aware that his conduct was reasonably certain to place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. Reckless conduct, a person acts recklessly as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a person younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person is aware of but consciously disregards that risk. Criminally negligent conduct. A person acts with criminal negligence as required by this offense if there is a substantial and unjustifiable risk that his conduct would place a child younger than 15 years of age in imminent danger of death, bodily injury, or physical or mental impairment. This risk is of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the person's standpoint, and the person ought to be aware of that risk. Bodily injury means physical pain, illness, or any impairment of physical condition. Designated emergency infant care provider means an emergency medical services provider, a hospital, or a child placing agency licensed by the Department of Family and Protective Services that agrees to act as a designated emergency infant care provider and has on staff a person who is licensed as a registered nurse and who will examine and provide emergency medical services to a child taken into possession by the agency. Excuse me. Application of the law to the facts. You must determine whether the state has proven beyond a reasonable doubt 6 elements. The elements are that number 1, the defendant in Uvalde County, Texas, on or about May 24th, 2022, engaged in one or more of the following omissions. A, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to engage, distract, or delay the shooter, or failed to attempt to engage, distract, or delay the shooter, or failed to otherwise act in a way to impede the shooter until after the shooter entered rooms 111 and 112 of Robb Elementary School and shot at a child or children in rooms 111 and 112, and or B, after hearing gunshots and after being advised of the general location of the shooter by witness 1 and having time to respond to the shooter, the defendant failed to follow his active shooter training to respond to the gunfire by advancing toward the gunfire until after the active shooter shot at one and more than one child or children in rooms 111 of Robb Elementary School. And number 3, Jose Manuel Flores Jr. was at the time a child younger than 15 years of age. And number 4, the defendant acted intentionally, knowingly, recklessly, or with criminal negligence. And number 5, the defendant was a peace officer for the Uvalde Consolidated Independent School District and had a duty to act by virtue of the provisions of the Endangering of a Child statute and or other state statutes, providing that he had a duty to perform the said acts that he omitted to perform. And number 6, the defendant's conduct was not a voluntary delivery of Jose Manuel Flores Jr. to a designated emergency infant care provider. You must all unanimously agree on the elements listed above. If you agree the state has failed to prove beyond a reasonable doubt one or more of the elements listed above, you must find the defendant not guilty of count 1, endangering a child. If you agree the state has proven beyond a reasonable doubt each of the elements listed above, you must find the defendant guilty of count 1. Stipulation of facts by the parties. The defendant has stipulated that the named child victims in the indictment either suffered death or physical bodily injury on May 24th, 2022 as a result of the mass shooting at Robb Elementary School in Uvalde, Texas. All right, counts 2 through 29, ladies and gentlemen, instructions on those counts endangering a child. The state accuses the defendant of having committed the same offense of endangering a child in counts 2 through 29. Specifically, the accusations in these counts are the same as those in count 1, except that the alleged victims, all children younger than 15 years of age, are as follows. Count 2, Azucio Sergio Garcia. Count 3, Xavier James Lopez. Count 4, J.C. Carmelo Ivanos. Count 5, Annabelle Guadalupe Rodriguez. Count 6, Alexandria Anaya Rubio. Count 7, Leila Marie Salazar. Count 8, Elena Torres. Count 9, Rogelio Fernandez Torres. Count 10, Nevia Alicia Bravo. Count 11, Jacqueline Jaden Casares. Count 12, McKenna Lee Elrod. Count 13, Elena A. Garcia. Count 14, Tess Marie Mata. Count 15, Miranda Gail Mathis. Count 16, Alethea Haven Ramirez. Count 17, Maita Elena Rodriguez. Count 18, Jayla Nicole Silguero. Count 19, Ameria Joe Garza. Count 20, Noah Oscar Arona. Count 21, Chloe Melinda Torres. Count 22, Jordan Demetrio Olivares. Count 23, Jadian Canizales. Count 24, Samuel N. Salinas. Count 25, Kendall Faith Olivares. Count 26, Mia Sorillo. Count 27, Gilberto E. Mata. Count 28, A.J. Martinez. Count 29, Maya Zamora. Relevant statutes and definitions in regard to the above. The relevant statutes and definitions for counts 2 through 29 are the same as those that have been set forth previously in the instructions for count 1. Application of the law to the facts, you must determine whether the state has proven beyond a reasonable doubt the same 6 elements listed in count 1 previously with respect to each of the remaining counts 2 through 29, except that the names of the victims alleged in these counts are different. Likewise, you must all unanimously agree on all such elements with respect to the remaining counts 2 through 29. With respect to each of the remaining counts 2 through 29, if you all agree the state has failed to prove beyond a reasonable doubt one or more of the 6 elements, you must find the defendant not guilty of that particular count. However, if you all agree that the state has proven beyond a reasonable doubt each of those 6 elements, you must find the defendant guilty of that particular count. Rules which control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go to the jury room. Your first task will be to pick your foreperson or your presiding juror. The foreperson should conduct the deliberations in an orderly manner. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with the other members on the verdict, and sign the verdict sheets. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. Number 3, you must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. Number 4, you must not conduct any independent investigations, research, or experiments. Number 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter alone. After you have arrived at your verdict, you are to use one of the forms attached to these instructions, you should have your verdict sign his or her name to the particular form that conforms to your unanimous verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Date, January 20th, 2026. Sid Harrell, judge presiding. Ladies and gentlemen, there are 29 verdict forms attached. They are all identical other than the name. I'm going to read the first form to you to illustrate what they all say, and the rest will be attached to the verdict for your consideration. Now, the verdict forms are not to suggest to you what your verdict should be. However, should you decide to use these verdict forms, each and every one must be signed by the presiding juror, the foreperson, indicating your unanimous verdict. Count one, verdict, not guilty. We, the jury, find the defendant, Adrian Gonzales, not guilty of count one, endangering a child as charged in the indictment, with a signature line for the foreperson and a line for the printed name of the foreperson. Verdict, guilty. We, the jury, find the defendant, Adrian Gonzales, guilty of count one, endangering a child as charged in the indictment. Again, signature line for the foreperson and a line for the printed name of the foreperson. Identical verdict forms for each of the 29 counts alleged. All right, ladies and gentlemen, at this time, both sides have an opportunity to argue the case. The state does have the burden of proof, so they have the opportunity to open and close the arguments. I will ask them to address you at this time.
Thank you, Your Honor. May it please the court. Abraham Lincoln said that it is much the duty of government to render prompt justice against itself as it is to render the same against the people. What he was saying was, we have a government comprised of prosecutors and police officers whose job it is to render justice against citizens when they violate the law. And that's what we're accustomed to. Prosecutors and police officers working together when someone has violated the law so that they may be held accountable, so that we may have peace and dignity in our state. But Lincoln reminded that no one is above the law, that those in government can also violate the law. And when that happens, it is the government's job to also render justice against those they work with. And so on May 24, 2022, when 19 children were slaughtered and 10 others were injured, Texas Rangers from all over the state came to Uvalde, Texas, investigated the crime scene, talked to witnesses, analyzed the case for up to a year. And after analyzing the case, one of the members of the government has been brought to you for justice. But ultimately, in our country, in a democracy, it is the people that decide their government. You do that by electing officials. You do that by sending letters or requests to have the law changed. And when one of the members of your government violates the law, you decide whether or not that is acceptable. Because make no mistake, the 12 of you will set the bar for law enforcement in these situations. If it's appropriate to stand outside hearing 100 shots while children are being slaughtered, that is your decision to tell the state of Texas. And by the same token, if that is not appropriate, that is not how we expect officers that are charged with the duty of protecting children to act, that will also go out from this court. The judge has told you that your oath was to render a true verdict according to the law and according to the facts. He has given you the law, and it is that same law that we discussed in Vordar some 2 weeks ago. You recall we talked about this is a special statute because we're dealing with a special group of people. We're dealing with children under 15 years of age, and so we're expected to act differently when we're talking about children that are frail, can't defend themselves, 15 years old or younger. And in this law, the law of child endangerment, none of us are allowed to endanger a child. None of us can point a gun at a child, put them in danger, put them in harm's way. But there is also the protection that if you have a duty to act, you can't stand by while the child is in imminent danger. If you have a duty to protect the child, you can't stand by and allow it to happen. We talked about the people that have a duty. Parents have a statutory duty, and police officers have a statutory duty. And those two sets of people cannot fail to act when a child is in imminent danger. And so the charge in this case is that these 29 children were in danger. Not just danger, but imminent, immediate, close at hand danger. And that there was a man who had a duty to act, who failed to act. And that failure to act, he was aware or should have been aware that that placed those children in danger. But we're also very specific about it. How is it that he failed to act? He failed to act after being aware that shots are fired, being told the general location of the of the gunman, having time to respond. He failed to act by either engaging, distracting, delaying, or even attempting to do those things. And also being aware that shots were fired and being advised of the general location of the shooter and having time to act and having been trained in that active shooter training. He failed to follow his training to respond by advancing toward the shooter until after the children in 111 and 112 had been shot. That is the obligation the state has to prove to you beyond a reasonable doubt. Two other quick mentions of the law that the judge has given you that I'm afraid we may not have discussed in detail on Vordar. The first was that the defendant must engage in a voluntary act. The first was on causation. We talked about when you have child endangerment by omission, there can be two people that can be held responsible. The person that is causing the danger and the person that has a duty to prevent that danger failing to act.
Yeah, I'm just going to object to that. Sorry, at this point, there's concurrent causation is is on his board that's not in the charge.
I'm not discussing that. That just now withdrew that, Judge, and I just didn't mark it off. I didn't say concurrent cause. I talked about what we talked about in the law that.
Okay. All right, I'll overrule the objection. Go ahead. Ladies and gentlemen, I just noticed the clerk brought to my attention, we were working on that charge yesterday. Your date's wrong on that. It's 21. It's January 21, the last page. So it says 20, but it's 21. You know that. Go ahead.
The second issue is voluntary. The defendant must engage in a voluntary act. That's as opposed to an involuntary act. An involuntary act, I believe we talked about during jury selection, is, if you stumble and knock somebody over an embankment and they're injured, that wasn't a voluntary act on your part. A gust of wind blows you into somebody. You're not responsible for that kind of conduct. If somebody swerves into oncoming traffic and hurts somebody, that certainly looks like you should be responsible for that conduct. But what if it was the very first time you'd experienced a heart attack and you lost control of the vehicle? That's not a voluntary act. That's an involuntary act. You're not responsible for that. But if you make a decision to seek cover and ask for cover as opposed to going in and stand by while people are being injured and killed, that is the kind of thing that's the voluntary act. It is defined in the statute. And finally, on mental states, there were 4. Intentional is not really something to discuss. Nobody believed that Adrian Gonzales meant for this to happen, wanted this to happen. But the other 3 deals with their level of awareness. Knowingly means simply you're aware that by standing by, it's reasonably certain the children will be in danger. Aware is reasonably certain. Reckless is 1 degree lower than that, and that is not that you're reasonably certain the conduct will happen, but reasonably certain that there is a risk, a substantial and unjustifiable risk that the children will be in danger. But there's still an awareness. But in addition to that, there's criminal negligence, in which the law is simply, you should have been aware, based on all those circumstances, that by you failing to act, the child was at risk. So that's the mental state. Not that he intended it, wanted it to happen, but at minimum, he should have been aware that by standing there, hearing 100 shots, he should have been aware the children were in danger by his failure to act. And so then we move into, and beyond the law, into what the state's case was. And it's pretty straightforward. This is not the order we put it in, but this is just the order I drew it up, because training is a big part of who Adrian Gonzales was. And you have the training that he trained others, because that tells you what he knows. And it also tells you a lot about what the state has done before you got here. In that lesson plan that was introduced into evidence, it tells you that amidst active shooting, the state of Texas stepped forward and required active shooter training for school police officers. And that active shooter training includes stop the killing, stop the dying. And it's not terribly complicated. The training is go to the gunman, advance toward the shots. Pretty straightforward. Not complicated, not hard. Go to where the gunfire is. That's what the training is. We brought you evidence that Adrian Gonzales taught the class that said, advance to the gunman, stop the killing, stop the dying. Even if you're the only one there, solo entry, you've got an obligation to go in. Why? Because in our state, we have a priority of life. Innocent civilians, their priority of safety is above the police officers. The officer going through this training is aware that the safety of the innocent is above the safety of the police officer. And in Adrian Gonzales' training, he says, the citizens have a right to expect that. And if you're not willing to do it as a first responder, find another career. Adrian Gonzales is teaching his fellow officers, take your job seriously. It's okay to move aside. It's okay if you're not up to that. Let somebody else step in that is up to it. Because as citizens, we have the right to expect that. When we call for help, we have the right to expect somebody that is put on the badge and put on the gun and put protect and serve on the side of their car will do that when we call. Because if they're not willing to do that, where are you? What are you left with when you're in danger? Who do you call? And so Adrian Gonzales, armed with this training, the next thing we spent a considerable amount of time on was the shot count. The casings along the west side, the casings along the hallway, the casings in 111, the casings in 112. And why did we spend all of the time on that? Because it's the state's position that each shot was noticed to Adrian Gonzales to advance toward the gunfire. Each shot was important to those 19 children and those 10 survivors. Each shot. But the shot count also, as we did that, and obviously if you have this kind of slaughter, there's going to be blood, and we apologize for that. But the blood also tells you a story of children engaged in this, doing as they were trained. To hide in the dark, remain quiet, and wait for the police. Did the defendant have time to act? We brought you videos, the funeral home videos, as well as the hallway videos, as well as dispatch, to tell you what he was aware of, when he was aware of it, and what was going on as he stood outside the fourth grade wing for 3.5 minutes before he made his first move, before he moved forward. We also brought you the defendant's statement. And the defendant's statement, I think, clears up almost the entire case. That is what he told the Texas Rangers shortly after this happened. If you're worried about whether or not he had notice and whether he had time to act and what his decision-making was, listen to these words from Adrian Gonzales. He's over there. He's over there. He's wearing black. I say where? I hear shots going off. Hear sounds coming from behind the building. Trying to get from the front of my vehicle to the back of my vehicle. There's only a tree and a building. She tells me he's over there. She's pointing, saying he's over there. He's dressed in black. I say where? She says the teacher's parking lot. I want to say I saw a black car at the end, and then I hear the rounds going off. When Melody Flores says he's over there, the teacher's parking lot, I hear the rounds going off. Some evidence of auditory exclusion. He tells the Rangers, as Melody Flores is telling him where he is, he hears the rounds going off. She goes, he's over there by the teacher's parking lot. Then I hear the sounds going off. I heard 7 to 9 shots while I was inside the building. The coach said parking lot in all black. That's when I heard the rounds start going off. I never saw him. I never went to the school until I got coverage over here. Then I made entry. I heard like 3 or 4 gunfire. When Pargas was the first one I saw, I told him to come to me for cover because he has a bigger unit. But he deterred and went to the other area. I knew there were kids in the class. That's why we didn't fire and hit the kids. I'm responding because they are saying the guy is running to the school. I didn't respond to the accident. That's a PD traffic. I'm going over there because they are saying the guy is going to the school and has a gun. Yeah, that's why I'm going to the school. And so the question is, if Melody Flores is telling him where he is, he's in black, when did she tell him that? Do you really suppose that someone who risked her life to go tell the kids to get inside the door, that is that worried about those children, that turns to run, that when the police officer gets there, doesn't immediately say what she told you she said? He's over there, he's in the parking lot. Where? And she points. And then says, we've got to get in there. And isn't that consistent with what human beings do? Look at Gilbert Lamons. When he sees children in danger, just as Melody Flores sees kids in danger, what does he start saying? Get in there, get in there, get in there, get in there, get in there. Repeats it over and over and over again because of the urgency of the children being in danger. And Adrian Gonzales decides to go to the back of his car, call Mariano Pargas because he's got a bigger unit, and says, I'm not going in until I get covered. We proved to you the children were in danger. And I know that was a horrible thing to have to experience. But each one of those children deserves to be revived. And you needed to know that those 60 shots in rooms 111 and 112 before Adrian Gonzales entered, those shots ended those kids' lives. This was over before he went in. A whole lot of blame for a whole lot of officers. This was over while he stood outside. And we anticipated that the defendant would say, I was confused, regardless of what he said in his statement. And so, certainly gunfire can be a confusing thing. But we brought you teachers that experienced that gunfire. And the teachers told you that experiencing that gunfire, they still put their kids first and they follow their training. Kids first, follow the training. Melody Flores did it. Miss Deming in room 104 did it. Miss Ogburn in 102 did it. Miss Robin did it with her children. And Mercedes Salas said, not till I get my kids out. You can talk about confusion, but their priorities were where they needed to be. Children first. And then we talk about the defendant's evidence, or the defendant's case, let me say. We started very early on that Monday, but he didn't have time because it was too far. It was 45 seconds over there. So we brought you evidence that somebody that covered that almost that same distance was able to do it at a jog in about 11 seconds. It was further than that, given 15, 18 seconds, but it certainly wasn't 45 seconds. And then there was the representation. There were no shots fired toward Melody Flores. There's no evidence of that. And so we brought you the evidence of the eight casings on the side of the parking lot, the shot into room 24. Well, those 8 shots were accidental discharge by a man bent on killing kids. He just made an accident, swung his gun around, and fired those shots, not toward Melody Flores, but toward that window. And so we brought you the casings. One picture shows 3 of the casings, which you'll remember the FBI agent said we had to go back several times, and so there's 2 more markers that are additional. There's 5 casings. There's 5 shots in the glass and 5 shots directly across up into the, not 5, but shots shrapnel up into the ceiling and down into the floor. So where are those 8 casings being fired? If we have those 5 taken care of, as well as in one room 104. Well, we have room 24. And so they tell you, well, that could have come out of room 111. So we brought you evidence that it was circular or almost oblong, saying that's the wrong angle. But more important than that, there's a piece of conduit running up the building. That bullet would have to pass through without leaving a mark. That evidence about Melody doesn't know what she's talking about is so you don't trust Melody Flores. And if you have any hesitancy on Melody Flores, go back to the defendant's statement where he says she told me where he was, what he was wearing. And then I heard the shots. We had a lot of information about slicing a pie and how long that must take. No way you have time. You got to get over to the side of the building and slice the pie. You can't do it quick. You have to do it slowly so you don't put yourself in harm's way. There's no evidence Adrian Gonzales got to a point where he could slice the pie. And we had evidence from their expert that said, slice the pie, how about taking a quick peek? You have cover, you have concealment, the gunman can't see you, you just peek around from a safe position. Well, it wasn't really cover. Well, it's not cover from the south side, but the gunman's over there. Adrian can see that way. It's not cover from the west side. If the gunman's over there, he's not over there, which Adrian can see. But it is covered from the northwest side, where the gunman is firing 16 shots. While Melody Flores is telling him he's over there. Echo, Adrian did tell the Rangers that there was an echo. So from his spot where he's standing, he's got to find out where that shot's coming from. And he can see on the east side it's not coming there. He can see on the south side it's not coming there. He can see on all directions except behind the building where Melody Flores is telling me he is. That's where it's coming. Not only that, but when Coronado runs up and he hears those shots within 2 seconds, he's saying, shots fired, get in the building. And Adrian Gonzales knows which building to go to. And Paige knows which building to go to. And they go to the building where the shots are fired and have been firing for 3.5 minutes. Well, let's talk about the doors, the responsibility of the doors. The doors would have slowed him up. Yes, the doors would have slowed him up. He had an AR rifle that penetrates glass. The glass is right next to the doors. He could have weakened that glass within a matter of seconds. It would have slowed him up 2 or 3 seconds to go through that door. You look at rooms 111 and 112 and you see the shots there surrounded around the window. May have slowed him up another couple of seconds if the door is locked. But we're not talking about a couple of seconds. We're talking about 3.5 minutes. Number one. Number two, the charge of endangering a child means you have to be aware the child is in imminent danger when you fail to act. And that failing to act, failing to lock the doors, did not happen as the gunman was firing the guns. The children weren't in imminent danger, immediate, close at hand danger when those doors weren't locked. Their failure to act at that point was not at the point where the children were in imminent danger, nor is there evidence they have a statutory duty to act. And in this case, let me say, there are adults we can be very disappointed in. There can be police officers we're very disappointed in. I don't know how you feel about everybody, all those people. I'm not proud. This is the case of the state of Texas versus Adrian Gonzales and the facts against him. And is he going to be held accountable for his lack of action? And so we concentrated our case on the facts against Adrian Gonzales. It's radio dispatch's fault because they didn't give significant enough information. They just said, wreck, man with gun, shots fired. They didn't say if he was shooting at the school or not. That's important information we should have known. But their expert got on the stand and said, wreck, man with a gun, what does that say? Not a lot. A man can be with a gun, but not be all that dangerous. But what about shots fired? His testimony was, then it gets real. What does that mean to a police officer? Shots fired. Then it gets real. Then on your way over there, you got time to know I'm facing somebody where there's shots fired. It reduces the confusion by the preparation. Shots fired. This is real. I've been trained. Shots fired at a school. Not the information in the school. Shots fired. Robb Elementary, man with a gun. I've been trained. I may have to go in solo. It was the police administration's fault because they didn't assign a person to each school. I suppose that statement is really, if they had assigned somebody, as long as it wasn't Adrian Gonzales, the outcome would have been different. The defendant's case, then we move to the other police officers, Page, Hill, Sauceda, Coronado. And they'll ask you to look through your court's charge and find where it says, evaluate the conduct of Page, Hill, Sauceda, or Coronado. You're here to decide one case. But we're glad to talk to you about these officers. Page, the funeral home tape alone shows you that he shows up 2.5 to 3 minutes after Adrian Gonzales is there. That, along with the Robb videotape, shows you that he entered the building within just 30 seconds. He shows up, there's shots going on, he assesses the situation in 30 seconds. He's acting. He's acting. Not failing to act. Hill, you recall that it's Hill's responsibility because he was called to Old Carrizo Road. He goes to Old Carrizo Road. He arrives there after the gunman is already inside the school. After the 16 shots from outside have already been fired on the other side of the school. The testimony was there was radio chat about setting up a perimeter. So he sets up a perimeter. Because here's what officers do. They get dispatched and they act. And when they get there, they assess a new set of information and they act. And after he sets up the perimeter, then he joins other people. And yes, the testimony was 25 minutes before he goes in. But Ruby Gonzales tells you that once those hallways get full, it can become dangerous to overcrowd that hallway. So you find other things to do. Well, if there's a perimeter, doesn't that count for Adrian too? If Adrian got the call to set up a perimeter and he goes there, so be it. But then you gather additional information. And that is 16 shots being fired outside, 24 shots being fired in the hallway, 60 shots being fired in classrooms, and a teacher saying he's over there, you got to get him. And you respond after you get the additional information. Sauceda shows up 30 seconds after the gunman has started shooting. The gunman shooting into the glass, into the classrooms. That's before Sauceda gets there. Halfway up, you know it's when Sauceda gets there because the bag is dropped. And then shots are fired. 6 shots are fired from behind a long row of cars. You're talking about him having an instant in which the gunman we know is hurrying the last part of that trip. We know the gunman is not firing into the building at that point. He's firing somewhere else. They think they're taking shots. If it's behind the vehicles, there's school classrooms with glass windows. If it's to the south and west, there's a man in dark blue or black. Permission to fire. Being careful. And then getting in his car in acting and following his sergeant to the end of the corner where Coronado says, I believe that's Salcedo. Also jogging to find the gunman. He's acting. And Coronado arrived to the sound of, he said he was receiving gunfire. The man at the funeral home is telling me, I think he says two. He's the officer that came that is used to these being bailouts, and maybe it's a road rage, and that's what he's used to doing, whereas a school officer is used to protecting the school grounds. And so he's thinking this is a road rage, and the guy's shooting at us because he doesn't want us to get him. So he goes around to cut him off. But in going around to cut him off, he's acting. He's acting to stop the shooter. You may not like his decision. You may not be proud of his decision, but he's acting. This is a failure to act case. And you know that he's acting because he jogs, he's looking for the gunman. And when he hears shots fired, he acts within 2 seconds. Get in the building, shots fired, and he goes in. He acts. And then the defense brought you evidence of the challenges that Adrian was facing. We start with tunnel vision. That's the whole issue about whether or not Adrian Gonzales saw the gunman in the parking lot. We have no trouble with the concept that he had tunnel vision and focused on the lady in peach. This charge does not start with Adrian Gonzales arriving at Robb Elementary. The charge starts specifically with, after hearing shots fired, after Melody Flores, witness number 1, which you can conclude now is Melody Flores, told him the general location of the shooter, and then having time to act. That's when the case starts. So he has tunnel vision. Okay. Auditory exclusion. Perhaps he didn't hear the shots. Then why would you tell the Rangers when Melody Flores told me where he was, I heard the shots? How does that happen? This was really complicated. Complicated set of facts I have to decide on. Complication, the training is you hear shots, you go to the gunfire. He heard shots and Melody Flores was pointing where to go to the gunfire. There's nothing complicated about that. He's wearing black. He's over in the teacher's parking lot. Go to the gunfire. Perimeter. Why doesn't Adrian get to set up a perimeter if Hill gets to? Why didn't Adrian tell the Rangers? I heard I was supposed to set up a perimeter. That's why I set up a perimeter. That isn't what he said. He said, I waited for cover before I was going in. And finally, this is an issue of stress. And this is my closing remark. I'm sure you're tired of listening to me. That was a dark day. For 29 families, it was extremely dark, and they still wait justice. And I can't let that darkness. But I can say this, there were some bright spots. In that stress, teachers put their kids first. In that stress, kids made ways to try to defend each other. In that stress, kids comforted teachers. In that stress, kids came first. Adrian Gonzales had a duty to put the kids first. And he called for cover.
proceed, Your Honor.
Yes, sir, please.
The monster who hurt those kids is dead. That monster is dead. And we told you from the beginning. And it is one of the worst things that ever happened. And I told you, the first time I stood up here and talked to you, I told you that you were not going to be the same person when you come out of this. And nor should you be. Nor should any of us. Witnessing horror, the tragedy, the loss, it's immeasurable. It's immeasurable. It's unthinkable. That loss is unthinkable. Their loss, it's unthinkable for any of us. You know, I told you guys before, I have a 4-year-old and 1-year-old. And, you know, we told you we're from San Antonio. And obviously, you know, I want to go back and see him on the weekends after the first week. I went back. The first thing I did was my 4-year-old came downstairs and I hugged him. Right? And hugged him. And started crying. And his hair, you know, trying to, so he doesn't see it. He said, "You sad, Daddy?" I said, "No, I'm happy. I'm holding you." Because I know what a privilege, doing this case, I know what a privilege it is to hold that child. I do. Right? I know, I can just imagine what it's like to not be able to do that. And I can imagine the pain, and I can imagine the anger. I can imagine wanting to put somebody in that chair because I can't put the monster that did that to my child in that chair. I can imagine. And I can imagine putting pressure. And I can imagine them responding to the pressure. And I can imagine them putting him in that chair. Him and only him. In that chair. To try to pay for the pain. To try to somehow this could cover the immeasurable and the immense loss. And so after I saw him on Friday, we have to come back here that Sunday for the first week. And Gary, he comes and picks me up. That's kind of what we've been doing. So my son comes out and he says, "Are you going to go help that man?" That's what we told him was the reason I'm not there. I said, "Yeah, in a minute, I'm going to go help that man." Adrian Gonzales. Because he needs my help. He needs our help. Because they, the government, the power of the state, has decided that he has to pay for the failures of that day, for the mistakes that were made that day, and for all the pain that they feel. And it's not right. Because the person that they plucked out and put in that chair, that person showed, we showed throughout this trial, that person was acting. He was acting. He was trying. And what I hear from the prosecutor, what I hear from the state, and what you've heard this entire time, what you've heard is that they will massage all the facts, they'll twist them all into a pretzel. That every one of these officers is fine, he's not. They'll twist it. Well, look who acted. They acted. Well, Adrian acted. Well, he didn't act the right way. They acted. Well, they didn't act the right way. Well, yeah, but he didn't act the right way, and he didn't know exactly what was going on, and he remained. Well, yeah, but Adrian remained in the hallway. Adrian remained in the hallway after he got shot at. Well, yeah, he remained in danger at that point, but before that point, he remained, and he didn't know what was going on. Every fact, that they've tried to bring. They've twisted it around. I'm going to show you. You're going to watch. I'm going to show you what they've done to twist this thing from the beginning to the end. But ultimately, what we're talking about is we're talking about duty, we're talking about burden, and all of those things. And I don't want one thing that I'm saying right now to make you believe that he doesn't believe that he has a duty to stop something that he knows is going on. Of course he does. He knows that. He was trying to do it. He started trying to do his duty. You look at some of these other people, no. They're not trying to do their duty. They're trying to stay back. And one of the things that the prosecutor said, he said, what you do here will tell law enforcement, give them how they respond. I'll tell you what, I agree with that, but not in the way that he's saying it. Because the way he wants you to believe it is what your verdict says is that next time these officers will make the right choice, the right decision. They will respond appropriately. They will be perfect. But the problem is that the issues here are not that Adrian failed to respond. They're not that he was intending not to engage. So you're not going to fix any of that, because I'll tell you, and I hope it never happens again. I think we all know that it probably will. But those officers, what your verdict says is not going to make them perfect the next time. It's not going to make them not make mistakes. It's not going to make them not interpret things differently, strangely, weirdly, based on their own experiences. That's not what it's going to do. But I'll tell you what it would do. If you convict them, they're all going to be Randy Hill on that perimeter. There's nobody going in. What do? You went in. You convict them. What does it tell all the police officers? It's going to tell them, I'm not getting in that crap. I'm not getting in that chair. If I see somebody running towards the school, I'm not going after them, because if I'm mistaken and it takes me to the other side of the building from where the shooter is, and then I can't understand or know where the shooter is, I can go to prison. I can get prosecuted. So what you tell police officers is don't go in, don't react, don't respond, stay on the perimeter, because Randy Hill isn't sitting in that chair. He's not. Adrian Gonzales is here. Randy Hill is not. None of those officers are in that chair. That's what you're going to tell them. You're going to tell them, don't do it. And you can't tell them that. It's like, I agree with them. You can't tell them that. We cannot have law enforcement feel that way. Feel like if they're not perfect, if they don't make a perfect decision. And that's where they go. Their family goes right there. There's nothing that's going to bring these kids back. There's nothing ever is going to solve that pain. Nothing, not that. Because one of the things that Bill said to you is, he said, those kids deserve to be remembered, and they do. But you do not honor their memory by doing an injustice in their name. You don't. That does not honor those children. By doing an injustice, by doing what they want you to do, by letting him massage the facts, by letting the pretzel go all the way around and miss everybody else, but keeps going right back to him, because that's what they need. We talk about the charge. If I can get it up. The duty. So remember this about what the court has read to you. And remember, I'm not saying he doesn't have a duty. Of course he does. But just like every officer, just like the officers in San Antonio, they all had the duty. But that's, and it may have sounded flippant when we compared it. We said, look, you're in San Antonio. There's a school shooting, right? You didn't stop it. Well, no, because it's not happening in the presence. And the reason we're asking that question is because the law is specific about it. A person, they have a duty to prevent an offense against a person about to be committed in his presence. So the first thing you have to figure out is that in his presence? You know, and the judge told you, you know, use common meanings, but he is here, and he never, they're not even disputing, he never saw the shooter, ever. He is never in the presence of the shooter. Now, what Bill may say is, well, he didn't go to the presence. But that's not what this law says. Law doesn't say you have to go and find yourself and make yourself be in the presence, and I'm not trying to make any excuse about that. But the law is the law is the law. This isn't about you have to go seek it out and make it happen in your presence. The law is saying if it's happening right there, there's a duty. Of course there is. He was doing his duty. He was running to the danger. He was driving right in there. If that was the gunman, and God, I wish it was, he would have ran right over. That's what he was doing. He's going 50 miles an hour at that person. Now, what I'm glad is he didn't run the person over because he realized it's Melody Flores. He realized it's a coach is what he thought, teacher's aide. But he realized who it was after it's already too late, but he's here. And from this point, that shooter is never in his presence, ever. There's never a time. The only time that he gets close is when he goes one of the first 5 people to go up that hallway. That is a hallway of death. Anyone going into that hallway knows, anyone knows, any police officer knows that those rifle rounds start coming that way as they're coming up the hallway. It's death. They don't have any equipment. They don't have anything to block it. It's death. He went in that hallway of death. See, and I thought about it because, you know, there's no way I can tell you about how they feel. But I thought about it as a parent. As a parent with kids there, if I knew that while my kid was in that classroom, somebody was going up that hallway, risking death to try to get to him, I'd appreciate it. I would. I mean, they're not perfect. But the person who did it, the monster, is dead. But he went up. A lot of people there didn't. A lot of people didn't enter that building until it was the room was surrounded on all sides by officers with rifles. Not one person on the side that he went in had one. Not one person had an AR. Not one person had a rifle. And they went in. Donald Page went in. Coronado went in. Chief Arredondo went in. People all went in and risked certain death. But the only time that he could have even been close to being in the presence of the shooter is when the shooter shot at him and Page through the wall. And you heard that testimony that there's gunshots going through the wall that they have to back up because not only can they not get to the door at all, they cannot get to the door. Joe Vasquez told you, that door, you're going to die at the door. You will die at the door. And I know that what the prosecution's saying is you should. Your job is to die at the door. But there was a lot of people out there. And if that's the training, die at the door, then everybody out there didn't follow. Everybody out there waited until there was shield. Everybody out there, Joe Vasquez included. Everybody. And you remember what Joe said? He said, thought his daughter could be in there, and he still waits 50 minutes for shields, for a plan, for BORTAC. So that's what I'm saying. They're twisting it around, and they're saying, well, his job, every shot was noticed that Adrian had to go in and be the person to die at the door, to be the person that tried to breach, solo entry with nothing. But nobody else did that. So is that the training? Right? Like that's one of the things that you have the right to go, because that's count 2, disregarding his training. Is that the training? Because if that is the training, and all these officers have been trained, and not one of them does it, but only one of them sits there, right? Like you have to twist it every time. For every fact has to be twisted around. That no other officer, I'm assuming, they made a point. Everybody's trained an active shooter. But that's why we pointed out that, well, now it's become a barricaded subject. And that training's different than active shooter. Now, some people are treating it like a hostage situation. And that's different than active shooter. And so the point is with this training was never meant to be twisted and used like this. You think that anybody that's putting on police training is going, yeah, and if you don't follow this, you're going to prison? That's not what they're doing. They're trying to give the best possible tactics and strategies to get to the best possible outcome. That's the point. But go back to the duty. If you find right there, honestly, he was never in the shooter's presence. Never was in his presence. Because that law, do not let them argue that law means that he has to go put himself in the presence. That law says it has to be in his presence. That's what that says. And if that's there, and you say that wasn't in his presence, then it doesn't apply. Under 605, he has the duty to prevent the threat, to do injury, if within his power. So they have to prove to you beyond a reasonable doubt that it's within his power. Because what they're not talking about is, no, this is saying you have the duty to go and follow the gunfire. That's not what this says. It doesn't say you have a duty to follow the gunfire. What it says is if it's within his power. So all of the officers before the breach, all the officers that and I don't have anything bad to say about Joe Vasquez. That man went in there. He went in there and he was willing to put his life on the line. But going in there like that in that room, it's not a whole lot different than going up that hallway, the first people to go up there without any protection, without any rifle rated anything, without any fire, without any rifles, without anything. But what that's telling you is that the reason that they waited is because it was within none of their power to get in that room. It was within none of their power to do that. It was not within his power to get in there and stop it. And it was not within any of those other guys until they got the right equipment. And then they went in and it was within their power. But if they haven't proven you beyond a reasonable doubt that Adrian could have done something to prevent, if beyond a reasonable doubt, then that doesn't apply. Then, of course, the education code just says he protects the safety and welfare of people in his jurisdiction. Well, of course. But that's not a duty. I don't even understand why it's there. It's not a duty to say, well, yes, and if you violate it, you go to prison. If you violate it, you're a convicted felon. If you violate it, you're going to be on trial. That's just telling police officers, and especially those who work at schools, that your duty is to do that. Of course it is. That's your job. Of course it is. But what we're talking about is we're talking about a man who is trying to do that. He is not trying to do that. He's not going, I'm not protecting anybody. Oh, shooter. And then drive off the other way. He doesn't drive around the building. He doesn't drive away from the gunfire. He's still trying to figure this out because we're talking about 1 minute and 48 seconds under their indictment. They keep saying 3 minutes, but it's 1 minute and 48 seconds. I showed you this in board hour. When we talk about beyond a reasonable doubt, possibly, probably, guilt likely, strong belief. If you have a strong belief that he had a duty, it's not guilty. Right there. That's why I'm talking about duty first, because as the prosecutor explained, if there's not a duty, then there's not. And not one of this is to be interpreted as me saying that he doesn't have a duty. We all have a duty to each other. He's a police officer. He's going to do what he can. But when we're talking about criminal charges, if you even have it's likely that he does have that duty. It's likely that it was within his power. It's likely that it was within his presence. I have a strong belief it was in his presence. I have a strong belief that it was within his power. That's not guilty. It's a verdict of not guilty right there. That's the first consideration. But going to the indictment, after hearing gunshots and after being advised of the general location of the shooter, and Nico's going to talk to you a lot more about this, it's convenient the way they're twisting it. It's convenient the way they're saying, well, of course, he was advised. She told him, 1, 2, 3, and told him exactly where it was, and she pointed over, she's over here, pointed over there, and he knew. That's how they're presenting it to you. But that's not how we know that that's not how it happened. We know, we have to know, because she is frantic. She is very unclear about a lot of things. And so if you have a reasonable doubt that he was advised of the general location of the shooter, that's not guilty. If you have a reasonable doubt that he had time to respond to the shooter, clicker slow on the uptake. Right, having time to respond to the shooter. If you have a reasonable doubt as to that, it's not guilty. Right, because what we established, even now when he's reading Adrian's statement, shots fired, or she told me where it was, shots fired, I radioed it out. He's compressing time in his interview. We're going to talk about that. He's compressing that time. The way he's telling it, she tells him, and then he communicates it on the radio. We know that that's not what happened. We know that from the time of shots fired to the time he communicates it on the radio is a longer period of time, which is accounted for by the fact that he is trying to get the information out of her. Once he does, he communicates it. Once he communicates it, we told you, it's a second after this monster's already gotten in. Not an unlocked door, but it's already gotten in that door. When he communicates this out, the guy's already there. So having time to respond. Once he finally figures out what it is, does he have time to respond? And if he does respond, we were showing you, if he does respond over here, he's responding to something that's not even there anymore. He's doing basically what Coronado does, which is go completely away from where they saw him go in and go all the way around the building. So if there's a reasonable doubt as to having time to respond, that's not guilty. any reasonable doubt as to any of these things, these are all elements that they have to prove to you beyond a reasonable doubt. And if there's any reasonable doubt as to any of these things, if there's a reasonable doubt as to Melody Flores and what she said, that doesn't say anything about her. That woman was traumatized. Of course she's going to be confused. Of course she's going to say it's a handgun when it's a rifle. Of course she's going to describe a completely different police car. Of course she's going to do those things because she's traumatized. But the reason we point those things out is they want him to be perfect, but they have to be perfect. They have to convince you perfectly, almost, beyond a reasonable doubt of their evidence. And that evidence rests on what did Melody Flores say and when did she say it? And they did not prove that. They did not prove it because even when she testified, Nico's going to go over it, she agreed that she was not just saying clearly, hi, this is what's happening, and this is where it is. She was saying a lot of different things. And it goes back to that chart. Anywhere you are, if you're suspected, if he's possibly guilty, if he's probably guilty, I told you, Bordier, I mean, most people get convicted at that probably. Because jurors go, hey, probably guilty, so they convict him. But that's not what the standard is. That's not what the law says. The law says it has to be beyond a reasonable doubt. It's the only way that our Constitution works. It's the only way our system of justice works. Now let's talk about this. Let's talk about Ranger Hill. Okay. Look at this. I froze it on this animation right there. Right at the point that Adrian's passing that spot. And that's where he has the shooter. He says it's approximate. Well, guess what? Approximate's not beyond a reasonable doubt. Their whole case is based on approximate guesses, speculation. We don't know. We're just really mad and we're upset that we have to put somebody here. Somebody's got to go in that chair because the guy who actually did this thing, the monster who did this, cannot go in that chair. He's dead. And good riddance. Good riddance. The devastation and the destruction he causes, unlike almost anything that has happened to us as a country, as a people, and definitely in the state of Texas, the devastation that he caused. Children that young and that many, good riddance. But that's not him. But they have to have somebody. So what do? They give you an animation that looks like that. Which, as we know, we had to bring a witness. We had to bring Claudia to tell you and to show you. Look, you'll see him. He's walking right there. And you see him walking in between those cars, and he stays there. Now, in a few seconds, you're going to see Adrian's car drive by. His head kind of popped down when it happens. He's going right there. You see the white car is flashing right through. That's Adrian driving by him between the cars. So what would an honest rendition of what you just saw, what Claudia testified, what does an honest rendition of that look like? It looks like that. That's what that animation should have looked like. Because we have actual proof. And Ranger Hill can't act like he didn't know that existed. He told you about the puff of smoke. That's the same video he's looking at. He knows that this guy's between the cars. But he told y'all, they sponsored it, that he was here. Why are they doing that? Because they're willing to twist things. They're willing to twist things for you guys in order for you to do their bidding. But those kids aren't honored by an injustice in their name. They're not. It's not honored by a conviction in their name.
And first the window going out and then went away. Melody Flores still urging Adrian Gonzales to go in. She sees the shot come through the window. Adrian Gonzales tells the police that she's the shot go through the window. Adrian Gonzales gets on the radio and says, guys, I think he's made it in the building.
See, that's what they told you at the beginning. They told you that Adrian Gonzales got on the radio and said, guys, I think he's made it in the building. Why are they telling you that? Because they want you to believe that he had that knowledge early, that he knew that he was in the building. What else did he say? In the opening statement to you, that Melody Flores saw the gunshot go through the window. When she testified, she said, I didn't see that. Why is it important? It's because Coronado radio, we've talked about it, and I feel like it keeps going into a memory hole every time it goes back over here. Right here, Coronado says, guys, I think he made it in the building. He established that. He said, he's the guy on the radio. He's the guy that thinks. Even Ranger Hill said, Coronado is the one who said that. Why did he say that? Because these three saw him do it. Because these three had line of sight. And he's radioing that around. And one thing we were clear to point out is that a gunshot did go off at the exact same time as that transmission. Why is that important? Because we don't know who heard that or who didn't. We don't know who heard Coronado go out and say that he's in the building. But we know that Coronado knew that or said that. And so that's the knowledge he has when he's driving around. Why is that important? Because prosecution, what are they trying to make you think? Coronado knew immediately that the gunshot fire was coming from the building. Coronado knew immediately. Look at Coronado. He knew it immediately. Of course he did. He saw him move the building on the side. He knew it from here. Once he came around here.
Actually, that's not admitted into evidence. There's no evidence that Coronado saw the shooter. There's no testimony of that or anything like that. So now he's misstating facts to the jury.
Okay, once again, ladies and gentlemen, what the lawyers say is not evidence. If the evidence, based upon your recollection, differs, rely on your own. You may proceed.
Well, and I can understand why they're trying to fight against that. Because look, this is, what I'm saying is we know that he radioed. I think he's in the building. When he's on this side of the building going to the other side, we know why. He testified. I thought he was going through the building, which implies that he knows that he went in to the building. But they keep fighting against that because this, knowing that he's gone into the building on this side, all their training, what does it say? Go to the gunfire. Even Ranger Hill they're twisting everything. They're twisting it all around. Ranger Hill said, well, yes, going to the gunfire is going all the way around here to the other side of the building, from where you saw him enter and from where you heard and saw him shooting into the building. So that to them is going to the gunfire. That to them is following their training, exactly how they're supposed to. That to them is working to distract, delay, all the things they charged him with. Well, they're not charged because they did that, even though they watched this happen. Had to have. And then Mike Whitskill. Now, I thought this was interesting. Mike Whitskill, I mean, he's an interesting guy. He said, I'm here as an expert witness in training, right? He didn't have any opinion. This is the interesting thing. The state had every opportunity to have Mike Whitskill go, I trained this guy. And I've seen all this stuff that you've given. And I reviewed all of these things. And Adrian Gonzales did not follow the training that I had. They had every opportunity to do that, and they didn't. They didn't ask him. He said, I didn't review anything. I don't have any opinion about whether or not Adrian Gonzales followed his training. In fact, you don't have any opinion at all. You don't have any real statement from anybody about whether or not he followed his training. And the things that you have from the officers are always with a caveat. Yes, you run to the gunfire if you know where it's coming from. If you don't know where it's coming from, you take cover and assess until you know where it is coming from. That's the first thing. You run towards the gunfire if you know where it's coming from. You look at their active shooter trainings. All the active shooter trainings involve them seeing the shooter and then going after the shooter, which makes sense. But they are prosecuting a person that they will have to admit, and they have admitted, and they've stipulated and never contested that Adrian never saw the shooter. I mean, he talked about the death by PowerPoint. In Adrian's 40-hour class that they were talking about, the 40-hour class he took, he said, look, we do 75-25, the practical versus the death by PowerPoint. I'll point out that, and you'll see that in the training that the prosecution mentioned about, well, Adrian taught a training. He facilitated a training. He did. There was somebody else who wrote the materials. There was somebody else who did it. And that's really what they kind of do. They have to facilitate for each other so that they can get their training out. But in these trainings that are happening, in the trainings that are going on, all of the trainings are training them to come in, have a rifle, come in, go in and be prepared to come in and do those things, and mainly to come in and see the shooter. Mainly to come in and know where the shots and the shooter is happening. And what they have done is they have just said, no, we don't care. Yeah, he said he didn't know where the shooter was. We don't believe him. We believe everybody else. Everybody else gets a pass. Everybody else. Randy Hill gets a pass. Saucedo gets a pass. Well, yeah. Saucedo said, I think I see him, permission to shoot. Well, we don't believe he said that. Or if he did say that, He had kids behind him, so he shouldn't shoot. That's crazy. That's crazy. Talking about this backdrop, them talking about this backdrop, that's crazy. And if that's the case, these officers are being overtrained on backdrop, because you do not fail to shoot a mass murderer of children because there's a backdrop where you could potentially shoot a child. You don't do that. You have to take that shot. And so if that's what they're saying, well, no, Sauceda has a reason why, because there's this backdrop. But then we pointed out, well, if Adrian did what they were asking him to do and came around here, we know now that by the time he transmitted, the guy's in the school, so he would have come around and nobody would be there. Thank you. But even if he came around and somebody was there, shooting back here that's his backdrop too. But no, not for him. No excuse we make for every other person there applies to him. And I think that there's something fundamental in each one of us. I think it's fundamental in each one of you that that's not fair. I think it's fundamental that that's not how justice is supposed to be done. It's not. It is not fair. It's not how justice is done, that they can do that and interpret every fact against him, but for everybody else, similarly situated or better situated. He agrees it takes 10,000 hours of practice to reach expertise. I mean, these are not experts. Adrian is not a SWAT expert. He is not an active shooter expert, right? He is doing the best he can, and this was obviously the worst situation of his or any of their law enforcement lives. 5 minutes to dress like one, 5 years to be one. I mean, the training is so extensive, and it's much, much more than Mike Whitskill gave 40 hours on that day. And then they talk about, well, you stop the killing, stop the dying. They never tell you how in these trainings. They never say how. They never say, how do you do it? How do you do it if it's just you and a gun and they have a rifle and you're in an open field? They don't say how. They just say, do it. Go in, win the game. Now, this is what in his instructor course, CME does not endorse nor encourage going it alone. See, what I'm saying is that these are sending mixed messages to the people who are being trained. They're reading this. They're seeing it. And then when you're talking about beyond a reasonable doubt on count 2, did he follow his training? It's like, even in the training, they're telling you, well, you should go in, but we don't endorse, we don't encourage it. Because having greater numbers significantly improves a first responder's odds for success. Now, what does that mean, odds for success? Because what they keep saying is that there's a continuum of life scale, and there's a priority of life scale, right? And then proof success. This is not saying odds for success meaning odds that I stay alive as an officer. Odds for success in being able to protect civilians. Odds for success in being able to actually do this. Because if you try to just run in and you don't have any of that shooter, remember the shield comes in when they finally came in, pop, 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 he's putting it right on the shield. The guy in the back of the stick, he comes in, shot in the head. That guy was ready. And anybody who approached that door was dead at the door. They were dead at that door. So what they're saying is the numbers improve the first responders' odds for success in saving lives, because a dead police officer is protecting no one. And that's what his training says. That's the person they brought you to say what his training was. That's what the training says. So they're sending mixed messages to these officers. And then if you better read the mixed message the right way, or the way they want you to read it, otherwise you're in this chair. It's not right. We saw the training pictures. This is how they're training to respond to active shooter. You got 2 people, you got rifles, they're coming in together, they're coming in different ways. That's how they're training. But that's not how it was. And we said in those hundreds of pictures, they didn't bring you one picture where they're coming in with all they got is a gun. All they got is a handgun. Not one in the hundreds that they took at that training. Because they're training these officers to have the right equipment. Adrian didn't, because the school district didn't buy it. Bailouts, we talked about it. Why is it important? Because everybody is responding strangely to this thing because of this wreck. They all think, they're going, well, it's okay that Coronado and them thought, well, this guy's running through the school because it's a bailout. He's just trying to get away from us. But it's not okay that Adrian thought that could happen. It's not okay that Adrian's standing here going, well, these guys are here and I'm here and I don't know where these shots are coming from, but he's probably trying to go here. I still have a whole school down here. It's not okay if Adrian thought bailout, no, he didn't follow his training. What Adrian said, he cooperated every time. Remember, this is a day later, and you know he's experiencing time compression. You know he's doing that because he's saying, I hear the shots. She's telling me I radio it out. That's not how it happened. So he's He's going through the same problems that we've talked about in all the other witnesses having to recount and recall what happened. He's having that same issue. He drove to the danger. And Nick will talk more about it. And then hindsight bias. And here's the thing that they keep trying to get him on. They go, because hindsight bias for Adrian is when he's telling the story about what happened, he says, yes, it was a female, it was a coach, because he now knows that that's the truth. At the time, though, he did not know that. At the time, he didn't think it was a woman. He thought it was the shooter at the time. But when he's telling the story, he's now telling it in a way, using the knowledge that he has, and he's explaining the story. And the same thing goes for when he's talking about what Melody Flores told him. When he's talking about what he understood, he did eventually understand what she was communicating and communicated it out. But in hindsight bias, he's not going through with the ranger, and the ranger's not asking, was she clear about it? Do we know beyond, did you know beyond a reasonable doubt when you got out of the car that she said that he's over there and you knew exactly where it was? He didn't follow up with any of that. So what Adrian's doing at the time of interview is he's skipping all that stuff. And he's getting to, I figured out what she was trying to say, and I communicated it out on the radio. He skipped it all because nobody's asking him. Because when they interviewed him, they're not prosecuting him. They don't think he did anything wrong. Nobody does. Nobody does. So years later, after all of this, they had somebody's got to go in that chair. So ultimately, it's the same thing I said from the beginning. You know, I've told my kid, and so I'm here, I'm helping this man. But I can't be the only one, and Nico can't be the only one, and Gary can't be the only one who needs your help too. Y'all are all citizens, and he needs you. He needs you to look at these facts as you have. And y'all have been very attentive, and y'all have to see very horrible things and hear horrible things. A lot of those things didn't have anything to do with those 3 minutes. Why did they bring it? You know why they brought it. You know why they tried to do it. The horror can make you so angry with him that you convict him. They played on your emotions. They presented all that in front of them. They're trying to do all of that, but they're not really going to what Adrian was experiencing and thinking and feeling on that day. But the one thing you do know, he went up that hallway. The one thing you do know, he went after somebody he thought was the gunman. That man didn't just stand by. He acted, except they just ignore all of his actions because they're trying to pretzel it, massage it, get it in there, do anything that they can to get the conviction. It's the most horrible thing, one of the most horrible things ever. One of the most horrible things that's ever happened in this state. But those kids are not served. The memory of those children that I agree should be honored is not honored by an injustice in their name. It's not. And so we're asking you to find them not guilty.
All right, ladies and gentlemen of the jury, we had discussed prior to beginning the argument to take a break at some point, and everybody agreed this would be a good time to do it. So take 10 minutes and we will resume the arguments, but do it as quickly as you can. We'll be in recess for 10 minutes. Remember my instructions, do not discuss the case. Do not discuss.
Okay, so folks, I'm still struggling with my voice. But
it almost got worse, Tanya.
Well, it's like the less I use it, the worse it gets. Right. Okay, so Bree West is our legal expert for today. See,
Yes.
it's like the more I talk.
Yes.
Talk to me about what you think about what we've heard so far.
Okay. Wow. What was the DA saying? It was disorganized. It was rambling. It almost felt stream of consciousness. But then you say to yourself, that was the opening to the closing argument for the state of Texas. Obviously, we sandwiched the defense in the middle, and then the prosecution gets to close the argument. But in the 45 minutes that the prosecutor was talking, he talked about the law, the facts, the defense case, their case. I mean, so what? What's left? I don't. But on top of everything, we really didn't hear anything.
Right.
So
He started with Abe Lincoln.
He started with Abe Lincoln. I mean, I think when we start with Abe Lincoln, we're all downhill, Tanya. We don't have a whole lot. So I'm worried about that. I think that obviously, from my perspective, I think the defense has done an outstanding job throughout the trial. I really do. I think that all of them have done an outstanding job. And I don't think that the closing argument was, I think that was right in line with how well of a command of that courtroom they have. And it's impressive. Now we're on a break, so I anticipate that the second half of the defense argument is going to be on the back end of this break. I know that lots of people are asking where Nico LaHood is, so I anticipate that he will be the second half of the defense.
I'm sure he will be.
Yeah. So, but up until this point, without a doubt, the defense has commanded these closing arguments.
I'm sorry. I'm looking at these comments and people are like, and they're wishing me well.
Oh, yes.
I appreciate that, guys.
She really is. She's okay, guys. I mean,
I
she
feel
sounds
fine.
really bad, but she's okay.
I sound horrible. It's my allergies. It's terrible. And it's terrible timing to have this happen. Let's talk about the one thing you were like, when he played the portion from the prosecutor's opening, you were like,
boss. That was gangster. So essentially what the defense did in preparing their closing argument is they took clips of the words of the prosecution that they made in their opening statement and prepared to use it against them in the defense's closing. That is gangster. I mean, that was phenomenal. I mean, how many gold stars can we give? I don't know. But we're joking about this, we're laughing about this, and it's not a joke. Obviously, this is very serious.
Look, it is with all. Yeah, and I agree with what you're saying.
Right.
What happened here? What happened in this school?
Right.
And I've said it, I don't know how many times.
Right.
What happened to these children? The law enforcement response was unexcusable.
Right.
It never should have happened.
Right.
It never should have taken 77 minutes. It's
Right.
all the things.
Right.
The question is, do you hold Adrian Gonzales accountable?
The question is, do you hold Adrian Gonzales alone accountable for all of the things, for all of the bad police work, for all of the miscommunication and confusion, for all of the fear, do you hold just him accountable?
I mean, they have charged, they have charged Peter Arredondo,
yes,
the former chief, but it's a little different situation because he is in charge. When he arrives, he becomes the incident commander.
Correct.
What did you think of, when Jason Goss is saying, the defense attorney is saying, look, they want to you to give a pass to Saucedo and who could have taken the shot and doesn't, and Coronado who makes the choice to drive around. Look, they're operating on the information. Essentially he's saying you want to give everybody else a pass,
right,
because of the confusion and what they're facing, but Adrian Gonzales,
right,
has to act perfectly. What do you think of that argument?
I thought it was perfect. I mean, and when I say perfect, what I mean is it was exactly the argument that should have been made, right? Like, in other words, that's not how our law is designed. That's not how we're set up. So the truth of the matter is Adrian Gonzales did act. He did do things. Maybe we don't agree that he did everything perfectly. Maybe we don't agree that he did everything as quickly. Maybe we don't agree that he, whatever the disagreements may be, but what we cannot say is that he didn't try. And that's really what we're dealing with here. Like, you're trying to criminalize the fact that you didn't think that he did enough or fast enough or whatever. But that's not what this statute is charging, right? It's saying you failed to act. You did not do. And that's not, they can't even, the prosecution can't even present evidence that says he did nothing.
Right. You don't like what he did.
You didn't like what he did, but not that he did nothing.
Right.
And we can't, I think we're on a very slippery slope if we start to say we're going to criminalize like the amount. Right? Like, I think we're on a dangerous path if we start doing that.
What did you think about when Goss starts with, that monster is dead?
Outstanding. I mean, and I think that, you and I talked about it, and I think that the defense team has done this throughout the trial to remind this jury that the person that killed these children, the person that affected this community in the way that has changed the trajectory of so many lives, that person is dead,
right,
and that person is not on trial.
Right.
And so let us bring it back to, as hard as it is, as emotional as this experience has been for everyone, like the 12 of you are sitting here because you said to us that you can separate those things. But we're going to remind you, we're going to remind you throughout the trial with every witness in opening and in closing, but you said that you can separate those things, and that's going to be their job.
What did you think when the prosecutor said the 12 of you will get to set the bar for law enforcement?
Yeah, I think that the way that the defense came back with that and said, okay, so they're asking you to set the bar for law enforcement to be absolutely perfect in every given situation, which is then going to ultimately result in law enforcement not acting because they're going to be scared that they can't be perfect. I mean, I thought that was, could it have been any more brilliant?
Because they said, well, you can be like Randy Hill. You can be like Randy Hill and stay on the perimeter. Sorry.
You could, okay, just so you guys, she said you could be like Randy Hill and stay on the perimeter. But yeah, so I just think that, I think that in a weird way, to say to a jury in this community where it's already this devastating, to put that kind of weight on the shoulders of the jury to say you're going to set the precedent for law enforcement going forward forever, that's too much. That's too much. And quite frankly, that's really not, that's not the precedent that we want.
Okay, so but we never know what a jury's going to do, right? I mean, we've sat here, I've listened to the entire trial, and I have seen juries. I will say this: every time I think I know what a jury's going to do, I am wrong.
Right.
Juries are but I've also always been impressed by how juries will really take their duty to heart. And somebody was saying in here they thought that we were in the not guilty camp. I'm not in any camp, but I have watched the entire trial, and I have covered law enforcement for a long time. And I think this is a really difficult case. It is a historic case.
Yes.
You have never had a police officer in the state of Texas be tried under this statute in this way.
Right. I mean, and I think that even the defense said, the statute is actually not meant to be used in this way, right? Like, that's not really what was contemplated as we're trying to twist and turn, and how much did you act versus how little you acted. I mean, that's not the intent behind it. And I agree. I mean, Tanya, what I think my position is I'm sort of evaluating the job that the prosecution is doing versus the job that the defense is doing, and what I think, how that's landing with the jury. So not in a camp, but I do think that, right now, the defense is outshining the prosecution in every way.
What do you think we're going to see next?
I think that you're going to sort of see the wrapping up. I think that
we'll see Nico. Obviously.
Okay, so Nico is going to be next.
It's got to be.
Nico. Like, who else is it? It's got to be Nico. And I think that he's going to bring, how he is, right? Like that charisma, moving around the courtroom, taking command. He's like not a gigantic person, but he feels, when you're watching him and you're listening to him, he's like a gigantic person. And so I think it's going to be that. And wrapping it up, I think there were global arguments on the front end of the defense, and so now we're going to get granular and really specific. And then you might ask me, so what is the prosecution going to do in their close? Tanya, I have no idea. I mean, I don't know.
Right.
I don't know, because unfortunately what they said in their open to close was literally instantly and immediately used against them in the defense's opening to their close. So I don't know how you clean that up on the back end.
After Nico, do you think they take a lunch break, or do they power on?
I think that they're taking, a 10-minute break now.
Right.
I think that presumably they may have like an hour and a half more.
At least.
I don't know how you don't feed people. I mean, you know what I mean? I know that they have a 10-minute break. Maybe somebody got a snack, but I don't know how you don't give them a lunch break.
But you're asking a lot of jurors. You're asking a lot of jurors.
You're asking a lot of them. Oh, okay. I think we're coming back, but you are asking a lot of them. I think that they may send them to the deliberation room and tell them, send us a note if you want to go to lunch. That's what that is what may happen.
gotta put my earpiece back in.
Yes. All right, members of the jury, when we recessed, the defense was in its closing argument. You may proceed.
Closing counsel. I think what we're all struggling with is how could one person do such a horrific and evil act to those children? And it's real. I mean, we're all thinking it. We're not immune from it. Everyone's thinking that. And the issue is that generates emotion. This has been an emotional trial. I can only imagine what it is to the families, and I'm going to talk about that in a second. I know it's been emotional for you. We've been watching you, rightfully so. It's been emotional to you. It's been emotional to us as well. Do you not think that burly man, when he goes home and he gave you that story about his son, that he's not digging his face in his chest, weeping? I have permission to say this because he did. Weeping. Do you not think that Gary, when he's doing FaceTime with his twins, that he stays on a little bit longer or lets them call past their bedtime so he can talk to them, never knowing if that's that last time? Do you not think that Michelle doesn't rush home to go to her granddaughter's games? Because she does. It's emotional for all of us. Or Joseph, and he gets away and disappears at the house that we're staying in because he wants to talk to his children, making sure they're okay. I shared with you in jury selection the journey my parents went on and my family went on with the murder of my brother in our driveway. Do you not think that when I close my eyes that I don't rethink picking up my mom off the ground in our driveway, loading my brother's body on the gurney after they finished the investigation and helping my pop wash off my brother's blood in our driveway? There's nothing like a mama's cry. Nothing like a mom's cry. You can't explain it. Nothing compares to it. And that's real. We don't ignore that. It's never been us against the family. It's never been Adrian against the family. It's been a pursuit for truth. Remember the totality of the circumstances? It's a pursuit for truth. And because this has been so emotional, the only way that can be dealt with in a justice system is through a jury trial. I love a jury trial. I love the justice system. Thomas Jefferson, as we talked about in jury selection, we talked about Thomas Jefferson. This has a little bit of a delay. I consider trial by jury as the only anchor ever yet imagined by man, by which the government can be held to the principles of its constitution. One of our founding fathers believed that. I do. In a system of the people, by the people, and for the people, you're the equalizer. You're the one that has the final say. With all due respect to the judge, who I respect very much, not him, not the bailiffs, not the government for sure, not even the defense, it's you, it's the people. And that's why I love a jury trial. And it deals with the emotion. It's the only way to balance this emotion and reason. And I say this respectfully as I can. They're trying to hijack your emotion to circumvent your reason. That's what they're trying to do. But they're your emotions, but they're being hijacked. And we know that. So how do you deal with that? Because in a world where we don't agree on anything, we definitely don't agree on politics. We don't agree on worldview and religion. We don't agree on definitions. Most people agree, no matter where you're at, most people agree that we don't want innocent people convicted and punished. Most people agree on that. And the only way we do that is through the justice system. And the representative of that is Lady Justice. She represents the justice system, not Lady Liberty, it's Lady Justice. And this comes back from the Greek times, the Roman times, where there was a polytheistic society and there was Greek gods, and she was the god. I don't believe in Greek gods or goddesses, but she was the goddess of order. The justice system is supposed to bring order to a society. And everything means something on this symbol, right? The blindfold means something. She doesn't look at politics. She doesn't look on whether you're a Hindu or Buddhist or Islamic or atheist or agnostic or that I'm a Christian. She doesn't look at any of that stuff. What she does is she tries to get the facts and the law and merge them together to reach this elusive concept called justice. The sword. The sword represents strength. The justice system has to be strong. There's something called the death penalty and life imprisonment That's in the justice system. So the justice system should have a sword aspect to it. And then her foot's on a book, because you have to have a command of the law, right? You have to know the law and have a commandment to dispense it properly. And her foot is on the book as she controls the law. And regardless of your religion or your worldview, the universal symbol of a serpent is evil. And the justice system should smash out evil in a society, true evil in a society. But yet she has those scales. And these scales are important. These scales say, I don't care about those cameras. These scales say, I don't care about the false narrative that's been out there. These scales say, I don't care about all the resources of the government. The scales even say, it doesn't even matter what the judge thinks. The scales says is we have to balance all that out, look at everything, and come find this concept called justice. And I love it. I love her. I loved her when I was a DA myself in Bexar County, as we talked about, when I made death penalty decisions, when Jason and I were prosecuting murders. I loved it. I love it as a defense attorney, sitting at that table, either defending people innocent like Adrian of an allegation by the government with all the resources. I love it. And in a world that has this dichotomy and this battle, the justice system brings us all together with a blindfold, not made of mesh, and not lifted up when it's convenient. Stays on the whole time. And so this is the point, though. This is the point in a trial, in a jury trial. This is the point in our justice system where Lady Justice takes the scales and she hands them to you. And now you have them. And that's what we're arguing to you. And that's what we've presented to you. And so all of this gets me to a point of where I'm in a dilemma. Let me tell you what my dilemma is. My dilemma is that I'm a passionate person, if you haven't noticed. And my passion, I think, can be a strength, but can also be a weakness. And so I wonder to myself, if I look like I haven't slept, it's because I haven't. Did I do too much? Was I too passionate? Was I too aggressive? Or did I not do enough? Did I not ask the right questions? Should I have gone even harder? And I struggle with that. But my dilemma is I can't apologize for it. And I won't be fake. And I won't tell you something that I don't believe. I haven't done that since jury selection. I won't start now. And so I can't apologize for it. And because I can't apologize for it, all I can do is ask you for grace. Just extend some grace to me. So if I've done anything, if Jason's done anything, if Gary's done anything to offend you, please, you don't have to now, you have to, please hold it against me or Jason or Gary, not against Adrian, okay? So that's what I'm asking you to do for us. And so we have to look at things, because what came up during the trial, and at the beginning when I told you, is there was a concept called totality of the circumstances, right? This case, ultimately, we're going to consider everything, allegedly. We want you to consider everything, but this case boils down truly to 1 minute and 48 seconds. Not 3.5 minutes, not 77 minutes, to 1 minute and 48 seconds. And it came up during the trial. And so Jason talked to, how do we know that? I'm not making that up. I'm going to their charging document. I'm going to their instrument that they charged Adrian. It goes up until after the shooter entered the room, 111 and 112. Until after the active shooter shot at one child or children in rooms 111. So until it's from when it's from showed up at this, it's from as the shooters, and until that shooter goes into those rooms and does what he did to those children. So we have times on that. That's what I'm saying. We have times. We know. Remember this? It's over here, but we took a picture of it. So Adrian parks. It's not contested. Adrian parks at 11:31:55. He parks. We'll talk about what he was responding to and how other people responded and how Adrian responded as he's going to what he thought was the danger. And we'll talk about shots fired. That's true. He calls shots fired because he hears them himself. But he parks at 11:31:55. He's not at 11:31:55 knows what's going on. At 11:31:55, he doesn't have a full concept of what's happening. He just parks at 11:31:55. And the shooter enters the building at 11:32:58. That's 1 minute and 3 seconds. And then some time goes by, 22 seconds later, he's shooting at those doors, and then 20 seconds later, he's in. If you add it all up, it's 1 minute and 48 seconds. That's what their indictment says. It's not 3.5 minutes. It's 1 minute and 48 seconds. Parked, enter the building. That's it. And then there's 22 seconds later, and then he enters again. 11:33:43. This is when he enters room 111. This is where we get the extra 45 seconds. And that's why I say 1 minute and 48 seconds. I'm going by facts that you've heard. They're charging and that no one's making things up on our side. Okay. I don't know what happened there. Give me 1 second. It held down on purpose. I'm trying. Give me 1 second, guys. Okay. Okay, so here's what the government wants you to compare Adrian's actions to others. So let's do that. And that's all we were doing during the trial. We were asking questions. We got permission. I mean, Mr. Espinosa sat to your right, and then Mr. Starbeck over your right shoulder, sir. And we asked everybody permission. For where you were sitting, Mr. Peña was between you two. And we remember in jury selection, we talked about that. And we got permission from you to be able to ask tough questions, even about sensitive matters. We did. And everyone said yes. So let's compare some actions. We're going to compare the actions of Mendoza, Saucedo, Coronado, and eventually Hill. And yes, they could figure that out during trial. So of course we're going to talk about it. So just to lay the ground, you guys know this already. So here's an aerial view. We can't even see Adrian's car. It's so much to the southeast side. But Coronado, Mendoza, Saucedo are on this side, a little bit outside. You've seen this picture multiple times. This is the scene. Here's a better view. We can see Adrian's car way over here. He's driving into the eye of the storm. Many witnesses said that. He drove all the way to the back. And then we had those 3 officers still at the corner. Here's the west door, and here's where the shooter was shooting. We have evidence of that, and then he enters this door at 11:32:48. So let's compare Adrian and Officer Mendoza. Adrian drove into danger. Officer Mendoza stayed away at the perimeter. Adrian had no line of sight, not contested. Christina's not going to come up here and tell you that he had line of sight. Mendoza was the same side. He was on the same side as the shooter. Adrian was alone. Mendoza had backup. Adrian was one of the first 5 in the building. Remember, we're going to talk about that first 5 because Joe Vasquez and others talked about that first 5 and what they did and what they potentially prevented. Mendoza enters the east door at 11. The east door, even though he's on the west side, the east door at 11:42:48. But before that, he drives away, not towards the gunfire. When he's facing the door, when he's looking, when he has backup, and someone has an AR-15, we're going to talk about Saucedo next. He drives away, not towards the gunfire. Remember that pretzel that Jason's talking about? There's one of them. Let's do some more comparisons because they're going to compare Adrian to everybody else. Adrian and Officer Saucedo. Adrian drove into danger. Officer Saucedo stayed away at the perimeter. Adrian, no line of sight. Saucedo saw the shooter, and we're going to look at the video in a second, and asked to shoot. Adrian, alone. Saucedo, God bless you, has backup. Adrian has a handgun only. Saucedo has an AR-15 rifle. Adrian, one of the first 5 in the building. Saucedo never goes in the building. After having line of sight, opportunity, and ability to do something, and he doesn't. He never goes in the building. And he also drives away, not towards the gunfire. So let's look at this. This is the dashboard of Coronado. Here's the sergeant. Mendoza's here. They set up perimeter. They're acting as if they're being shot at, but there's no evidence. There's no defects. There's no objective evidence they got shot at. Here's Saucedo. There's a long rifle. Watch his behavior. Watch him aim. And watch him do this point. He's there. He's there. There he is. He had aimed him. He saw. He's pointing at him. He's there. And then they saw him walk into the building, so they leave. We're coming back to this video.
There's no evidence that's a misstatement of the facts, Your Honor.
No, it's not,
I'm
Judge.
going to object. I want it on the record that he's misstating facts to the jury.
Okay, once again, ladies and gentlemen, what they say in argument's not evidence. If it differs from your own recollection or rely on your own, you may proceed.
It's in evidence, guys. I asked questions. I was very specific about questions. I gave people opportunities to talk. I wasn't trying to be a bulldog on anybody. Maybe you can think I was on Ranger Hill. We'll talk about that in a second. But we're just asking questions, specific questions, not general ones, okay? So let's talk about Officer Coronado, Sergeant Coronado. Adrian drove into danger. Sarge stayed away at the perimeter. Adrian, no line of sight. Sarge, same side as the shooter. Adrian, alone. Coronado has backup. Adrian, frantic witness he was dealing with. Coronado, frantic witness he was dealing with Claudia. Remember that? We're gonna look at the video again and you'll see it. Adrian, unfortunately, and again, we're not ragging on her, okay? You saw me cross her, but she was wrong, and we'll talk about so many things that she was inaccurate about. A frantic witness that was wrong and inaccurate because she was on the wrong side of this issue. But the frantic witness, Claudia, the sergeant, on the same side, was accurate. Because you know why? Because she said, he went in the building. He went in the building. And you see the video yourself that they're acting like they knew he went in the building. Because you don't go from this, thinking you're being shot at, to this unless you know that the danger is gone and they're in the building. You saw the video yourself, and we're going to watch it again. Sergeant Coronado unfortunately drives away, not towards the gunfire. So now we're going to watch it again, but now we're going to focus on Sergeant Coronado, okay? This is him again. We already looked at Saucedo's behavior. Look who he's talking to. He's yelling at somebody, and that's Claudia. You go inside, okay, what? They're talking. She testified, I told them he went in the building. And guess what? He acts like he knew he went in the building. Because you don't go from ducking like that to watch his car drive off. Watch all of them. They all know he went in the building. They don't believe what they're trying to prosecute. There's no way. Our defense is not, well, if you're going to prosecute Adrian and prosecute other people, they don't believe it themselves. You can't. I'm going to go through a list in a little while of all the things that they're going to have to, Christina, with all due respect, is going to have to come up here and tell you to ignore to get to the man at the bottom of the totem pole. I'm going to show you that list, and I'll be right, humbly, but I'll be right. Where's Randy Hill? I know it bothers them because he's the one dispatched. Why didn't they call him? Why didn't they call Saucedo? So we can ask them questions and bring you answers. The government has all the resources, all the rangers, this whole road. They had the whole government of Texas and all the resources to bring you evidence. And we expect that of them. Where's Randy Hill? Where's Mendoza? Where's Saucedo? None of them. The only reason why they brought Coronado is because they wanted that video in. He's dispatched at 11:29:36, 3 minutes before the shooter enters into the building. What was 911 told? That is another aspect of it. Bill's right. I mean, he could hear. He's an intelligent man, and tremendous respect for him. But he heard our questions. I mean, that's a factor. We have to. If we're looking at the totality, what were they told? What information did they all have? Someone shooting a gun. This is what Mr. Limones told dispatch. They just shot at us. He's shooting at the school. That wasn't relayed to anybody. He's jumping into the schoolyard. Wasn't relayed to anybody. He just jumped over the fence. Still wasn't relayed to anybody. He's running towards the school. Nobody knew that, but that nobody knew that includes Adrian. That includes Adrian. He's wearing black. No one knew that. That would have been helpful to know. But we know for sure, and I know Ranger Hill's here. He can come sit right here if he wants to. I asked him, you don't know, I know when he showed up on the scene. You do? It wasn't in your critical timeline. Well, it's in a different timeline that he gave to them, didn't give to us. Interesting. But so in his critical timeline that he didn't review for 3 years before he sat in front of you and told and testified to this, he said that that's all that's in his critical timeline, not when Randy Hill supposedly showed up, because Randy Hill didn't check in at location. Let me know what's going on. Nothing. No communication. So all we have in the first critical timeline is this. Randy Hill at 11:33:32. Just standing there. Said, did you hear how difficult it was for him to try to make up an excuse for what Randy Hill's behavior was? Did you hear how difficult it was? Because you couldn't objectively do it. Not based off Nico standards or Jason standards, just training standards, tactics. I asked him tactical questions. How does this make sense? Well, he was just there momentarily. Where's that? I don't understand where you're getting this from. What we know for sure is that Sergeant Coronado is driving around the school, and there's Randy Hill. He's already out of his car. He's been there for a little while. I don't know how much it is. The ranger thought he knew. I don't know how. But there he is, setting up perimeter when nobody's asked him to set up perimeter. Oh, they said there's a dispatch, again, that we didn't get from an unknown person. Remember that exchange? Figure it out.
Again, object. This is misleading the jury, and he's having them believe that we did not turn over everything to him, and it's
Okay. So we'll
remember that exchange? I was just asking questions based off the evidence that we were looking at. I let him, what are you looking at, so I can ask you about what you have in front of you. There was no trick question, no gotcha. I told him I'm not going to question your character, but I will question your opinions. I'm going to question your investigation. He knew that. He knew that. He's coming before you after 3 years of all of this and the resources, 3 years, and that's what they brought you? That's the mortar to their case, Ranger Hill? Bringing it all together in his critical timeline? Well, where's Randy Hill? We all want to hear from Randy Hill. And then we have a hero, a true hero, Joe Vasquez. You heard about Joe. I mean, he gave me permission to call him Joe. He called me whatever he wants to, but we went through scenarios. We went through breaching. We talked about when you breach an outward swinging door versus inward swinging door. Well, what did Joe tell us? At 11:56:28, he linked up with Lieutenant Gonzales, who briefed him. Very different when you're being briefed by fellow cops after the situation has already been assessed. Very different, but they want to conflate that to Adrian. Well, they did that. They listened to instructions. They moved in. We have 27 officers around with everybody has guns and helmets and vests on and AR-15s and said, here's what's going on. And oh, yeah, of course they're going to listen. That wasn't Adrian. I asked if he wanted me to make entry. He didn't do. He asked. He understands there's an order. He understands the danger of it. We talked about the danger of it and fatal funnels, and there was two of them. There was the hallway, and then there was the actual doorway. We talked about that. Response, no, we're trying to negotiate because we've been fired at. That's what he was told. Waited with Gonzales for negotiating team and the tech team. So a true hero. I hope you like Joe, because I like Joe. I mean, he waited. There was still sporadic shooting at times. We look at the timelines, the critical timeline that's kind of complete. But he waited with Gonzales for the negotiation and the tech team. Should Joe be sitting in that chair? Is Joe a coward? Are Bortak a coward? Are all the other officers cowards? Eventually, Bortak showed up. It was a bit of a blur. He doesn't remember. A lot was going on. Then they had a planning. They planned the entry. How long did you wait there? I asked them that. They entered at 12:50:01, almost an hour after he arrived. So Joe Vasquez is a real hero. He thought his daughter was in there. Could have been in there because she went to school there. But he still waited an hour because he knows there's a pecking order. He knows there's a way. He understands fatal funnels. He said, you're going to die at the door. That's what he said. We got that from Joe, not from us. And he waited because they were planning entry. Part of their training too. Waited 50 minutes, over 50 minutes. But Bortak was rehearsing and opened the door. And again, I'm not saying that's good or bad. That's what part of their training, because an open, outward swinging doors is difficult and it's dangerous. But they had the equipment at that time. Adrian didn't. The first 5 didn't. Taking cover is reasonable. Then we asked them about Adrian's behavior because they didn't bring an expert, so we had to ask somebody, and we're going to ask somebody who's in law enforcement. Well, taking cover is reasonable if you don't know where the shots are coming from. From Joe, their witness. Containment. Remember I asked about containment? We talked about that. And he said, if those first 5 officers, we call them the first 5, if the first 5 hadn't contained the shooter, he could have done the same thing to the whole school. Think about that. When he didn't contain, he didn't do anything to distract or detain or to impede. That first 5 group held them in 111 and 112. And let me submit to you humbly. If it wasn't for that first 5, that person responsible, because I know I've called him an animal and I know I've called him a monster because he is. You get the point. But if it wasn't for that first 5, what would have stopped him from finishing off those precious babies in 112? Was it a distraction? He knew there was talking, there's negotiating, he waiting for them. He wants to be a cop killer too. He wants to be a cop killer, so he's distracted. He's done damage he's done what he's done in 111. He did what he did in 112. But what would have stopped him to finish everybody off? The 5 outside, knowing that they could breach at any time. He doesn't know what they're doing. And he was waiting in that closet. He knows that closet, remember? 111 was his home room. He was going to 111. He went to school there. 111 was his home room. He knew that room. But even Joe Vasquez said, if those first 5 hadn't contained the shooter, and by the way, and I know it bothers them, Adrian's part of that first 5. And not that 3.5 minutes that Christina's going to come up and argue, that minute and 48 seconds with no line of sight. Talking to the guy on the stick. He was talking to the guy on the stick. Remember that stick is the stack when they're breaching behind the shield? He said he couldn't hear me because I realized I was wearing a gas mask. He himself was experiencing perception distortion. He didn't even realize he had a gas mask on. There was no gas, but he put it on and he couldn't hear. And he's talking like, oh, what am I doing with this gas mask on? And so he took it off to talk, but he didn't realize it at the time. But it's okay for everybody else except for Adrian because he's the man on the bottom on the totem pole. He's easy pickings. Except for you guys to settle that. Now let's talk about Mel Flores. Look, I mean, if you couldn't tell that I had an affinity for her because she's a special ed teacher, then you weren't paying attention. I have a special needs son, and I told her that, and I appreciate that. And it takes a special person to spend 25 years teaching and taking care of and nurturing and stewarding special needs children. No one is attacking her character. But she came in almost 7 days after the event. She admitted she's watching these cameras and reading the stories and listening to talk. And that's human. That's normal. She wasn't given an order by the judge or anybody else not to talk to anybody, but that was influencing her talk. And so, but she's witness 1. She's in their indictment. The training and then witness 1, based off what she said. She thought the shooter had a handgun. She was sure of it, but he didn't have a handgun. Did not see the windows break on the east side of the building. I could not see from where I was, but Bill, in opening statements, expected you to say that she did. Why? Because that puts Adrian in a disadvantaged position. But then the truth came out during cross-examination, right? Remember we talked about that in jury selection, the greatest vehicle ever invented to find the truth, I was taught, is cross-examination. It's in Proverbs as well. Because we had to, and we asked you, and I told you that direct examination for the government was going to be like a waltz, and then cross-examination was going to be like a dental visit, pulling teeth, and I think you saw that. It wasn't our intent. We can't control the way the witnesses respond, but some of them were very honest. State Exhibit 921 identifies the wrong PD. She identified the wrong PD vehicle. She identified Sergeant Page's vehicle. She ID'd Donald Page. Khaki pants, Adrian didn't have khaki pants on. Full beard, Adrian didn't have a full beard. You saw the interview. Short sleeves, white short sleeve shirt. Adrian wasn't wearing white short sleeve shirt. We believe she saw Sergeant Page, but she also testified that she was frantic. Yes, I was. Let me submit to you respectfully. Again, this is nothing against Ms. Flores. God bless her. Let me submit to you that you heard the 911 call from Mr. Limones. You heard Amy Marin's 911 call. Understandably, it's frantic in the background. You heard Claudia in the background of Mr. Limones' 911 call. Ms. Flores was more like that. Adrian's dealing with that type of franticness. Understandably, again, it's not a criticism, it's just an observation. He was pacing. Remember we talked about that? Assessing because you're shouting, yes, they're shouting, south entrance, west entrance, shots fired. And we'll talk about when he transmits something in a second at 11:32:59. She was with Adrian from 2 to 7 minutes. You can't cherry pick what you want to believe from her, Christina. You just can't do that. Or you shouldn't do that. It's not right. It's not fair. I mean, so we know it couldn't have been 7 minutes because the timelines don't work out. The stuff that we do know, it couldn't have been 7 minutes. But even if it's 2 minutes, it covers the 1 minute, 48 seconds that Adrian had no eyesight on the shooter. He had no opportunity. He didn't have the ability. He's with her. She's a victim/witness at the time, yelling, frantic, giving instructions. He's taking shots. He's looking around. He's taking cover. See, it's okay for everyone else to take cover but Adrian. For a minute, he can't take cover for a minute to observe, orient, decide, and then act. Remember their training? But she's going to have to come up here and tell you it's okay for Coronado, for Saucedo, and for Mendoza to take cover and then run from the shooting, run from the gunfire. Make a note, run from the gunfire, not run to the gunfire.
Your Honor, I'm going to object to the sidebar comment.
Sustained.
So She's going to have to argue that to you. And I don't know how you do it in good conscience. I just don't know how you do that. But 2 to 7 minutes, it's a big deal. That's a big deal because it came out in evidence, and you should consider that. And the reason why it's in the big deal, I want to say this because I asked Ranger Hill. I said, well, why isn't that in your timeline? Why didn't you know that information? I go, would that have been important? And he said, yes, it would have been important. So good for answering that way because it's true. It would have been important for him to assess critical, important, his definition, important timeline, 2 to 7 minutes with a witness / potential victim. It matters in your assessment of someone's behavior and what they didn't do and what they were actually doing. Excuse me. Shots being fired while with Adrian Gonzales. Yes, while they're together. So now he has somebody he has to protect as well. And himself and her, and think about it. He has no idea that this person's going, he doesn't know that. There's no evidence that he knew he was going in the building. He's going in the building, Adrian. There's no evidence of that. He couldn't even see this guy. And we said pacing could be taking cover. She says, I'm sure. Said the shooter went in the south door, but pointed to the west side. Yes, I did. And then in her interview, the investigator, the ranger, had to say he did not go in the south side. Oh, I really thought he did. And she was honest about it. I really thought she was mistaken. She just was inaccurate. At the time, he thought the shooter went in the south door. Yes. Told him the 4th grade building. He said, what building? He doesn't even know that. He's not part of that. He's assigned to the high school. He didn't even know which building you're talking about. Yes. I just wasn't listening, she said, because there was a lot going on for her. That's understandable. Then said he's on the west side of the building. Yes. So south side entrance, west side building. Yes. Dialogue between you two was 2 to 7 minutes. Yes. So here we go. Adrian with her 2 to 7 minutes. Shots being fired while with Adrian. Yes. You say pacing could have been taking cover. Yes. Said shooter went in the south. Yes. At the time you thought the shooter went in the south door. I did. Yes. Told him 4th grade building. He said what building? Yes. So there's confusion there. Not confusion like he's confused. He's trying to figure things out. He doesn't even know where she doesn't even know where she's directing him to. And again, there's a lot going on for her. Dialogue, yes. It just wasn't listening. Now we have Ranger Nick Hill. And I'm sorry, Christine, I didn't mean to be disrespectful to you. I apologize. I'm going to temper myself. I really believe, with all due respect, Ranger, I really do believe that Thomas Jefferson was talking about someone like Ranger Hill. And I'm saying that with him in the room. I consider trial by jury you as the only anchor ever yet imagined by man, by which the government, including him, the government, can be held to the principles of its constitution. And one of those principles is due process. You know what due process means? It means fundamental fair play. Fundamental fair play. Everybody gets it. Remember that blindfold? We don't do this. Doesn't apply to you. Can apply to you. Doesn't apply to you, sir. Applies to you, ma'am. It doesn't work that way. That's not how Lady Justice operates. That's why she's so beautiful. She wears that blindfold at all time. I'm not going to go over all of Ranger Hill's testimony and our back and forth. And again, if I offended you by my question of him, please hold it against me. I can only ask you to do that and extend some grace to me. But like Jason said, this was his presentation to you in good conscience. This was, and if you had not known any better, if we didn't ask questions, if we didn't push back, you would think that the shooter was right there and then he just drove right by him. That's it. And then he placed the shooter where the shells were, and then we went through the whole ejection thing. Remember that? And it was at versus towards, and can you look at two people, and how many fingers am I holding up? We went through a whole bunch of stuff, and I just asked him pretty simple questions. But that's how you presented it to you, and that's not the facts. Jason told you. We know that because we have some video. Grainy, yes, we have video. But more importantly, we have Claudia, who he interviewed. He didn't review someone else's interview. He interviewed her. And not only does she, but also Mr. Limones and even Amy Marin loses the shooter in between cars. He's in between cars. That's where he should have been if he was going to present that to you, this animation. But the government sponsored him anyway. Now, whether they knew or didn't realize it, I don't know. I'm not inside their minds, and that's between them. But they sponsored him anyway. So what is Christina going to come here and say to you? 3 minutes. She'll say 3.5 maybe. Okay, because Bill kind of gave you the heads up on that. Didn't follow training. Well, Jason went over the training, so I asked him a lot of questions. I talked about tactics with him. He was very, very nice man. He agreed. Just my opinion. I'm one opinion of many. There's different. These are suggestions. And I said, I understand. Thank you, sir. Very respectful. Didn't follow training. Then we showed you the training. We don't recommend going in alone. But we're not even saying Adrian made that conscious decision, by the way. We're talking about 1:48 seconds. Had an opportunity, best opportunity. I mean, Ranger Hill, over the 3 in the corner, said that Adrian had a better opportunity to stop that shooter than Coronado, Saucedo, and Mendoza. You're the judge of the credibility. That's why you're here. That's why I love the jury section, the jury trial. And here's what they're going to do. They didn't say it, but they're saying it. They're trying to feed you a coward sandwich. They want you to eat a big coward sandwich and say that Adrian's the one that gave it to you. The problem is, it is wrapped around 2 slices of bread of bravery. That's the problem. You have this coward sandwich, but you have bravery and bravery around it. The bravery of driving into trouble, thinking there was a shooter. Only one, didn't set up perimeter, goes into the trouble, into the eye of the storm. And then he's one of the first 5 that goes in the building. Takes rounds, what Martinez does, takes rounds, and you saw the video. Adrian has his weapon out. He doesn't move. Page is there. He's in the fatal funnel. All that shooter needed to do was turn this way and start shooting at them. He didn't run away. He only went outside when his radio didn't break, because the radios don't work inside of schools, which is interesting. And so then he had to go outside to call for SWAT, call for cover. Everybody's doing that. It's for the cover for the situation, not for him. That wasn't accurate. And then what Bill told you in opening is that Adrian, if you listen to Bill's opening, and again, this is respectfully, you would think that Adrian showed up and just stayed there and stood there. If you remember opening, I don't know if you do or don't, but that he just stood there and didn't do anything. And the evidence didn't play that out. The only thing Adrian remained in, he remained in danger. He went into the danger and remained. Once he figured things out, he went further into danger and remained. That's the only thing he remained in. And they're going to ask you to send the message. Jason couldn't help himself. He had to talk about it, and I understand. The problem is the message that will be sent is be Officer Hill. Set up perimeter, even though you're not asked to set up perimeter. Don't go in. Don't go into the eye of the storm. Don't even wait 30 minutes. Stand back. Don't do anything, because I don't want to be sitting in that chair. That's the message that will be sent, not just to Uvalde County, but also to Nueces County, Bexar County, because people are watching. And that's the message that would be sent. That's not the message that needs to be sent. They need training. They need good training. They need proper training. They need resources. They need help from those schools to work with them in conjunction. And we'll talk about doors being locked here in a second. And then all working synergistically together to protect the most precious thing we have in our community, and that's our children. No doubt about that. But to pick the man lowest on the totem pole and drag him into court and to come before you, there's a lot of things they're going to have to ask you to ignore. They're going to have to ask you to ignore inaccurate dispatch. They have to. I'm not saying it's their fault, but they're going to have to ask you to ignore it. They're going to have to ask you to ignore that Adrian drove into danger. Remember that sandwich? They're going to say, yeah, okay, the bread is fine, but the coward sandwich is full in the middle. And then, yeah, I understand the bread at the end is bravery, but we just want you to focus on what's in the middle. It's like an Oreo where you take off the up top. They want you to have the coward cream in the middle. Remained in danger. They're going to have to ask you to ignore that he remained in danger, that he had no line of sight. They're going to have to ask you to ignore that. He never had a line of sight, but other officers did, not him. They're going to have to ask you to ignore that it was truly, because I looked at the indictment and we're looking at the facts. It's truly 1:48 seconds. They're going to have to ask you to ignore that. She's going to argue something different, and give her your attention, please. They're going to have to ask you to ignore that. They're going to have to ask you to ignore Mendoza, who showed up 28 seconds after Adrian. That's it. That's the difference. He was there too, before the shooter made it in, with line of sight, with backup, with guns, with superior weapons. They're going to have to ask you to ignore Saucedo. Line of sight, never goes in, drives away. You saw the video yourself on the dash cam. They're going to have to ask you to ignore Sergeant Coronado. They're going to have to ask you to ignore Randy Hill. They're going to have to ask you to ignore building doors being unlocked. Everybody, Wixel, all of them, all the Rangers said if those doors were locked, it would have made a difference. Since time is of the essence, those doors being locked would have made a difference, because you had 3 officers on that side. You had 3 officers on the side, on the west side, one with an AR-15, getting instruction from Claudia. He's going in the building. They're right there. And if you would have been locked out, you don't think that would have made a difference? But they have to ask you to ignore that. I don't know what you do with the school board on that. That's not what this trial is about. But you have to ignore that. They're going to have to ask you to ignore that. But it's not that important. It's more about Adrian. The classroom door is being unlocked. I'm sorry for what Mr. Reyes went through, but that door was unlocked, and it should have been locked. That would have made a difference, a key difference. You know what really made a difference? If that door was unlocked and those 3 officers in the corner followed the gunfire and made it in the west door, not drive around for whatever reason. You can talk about, I want to hear the excuse. Made it, and then the shooter's in the fatal funnel. This door's locked, even if he got into the school. The classroom door's locked. And he starts shooting at the door, but then here's these 3 officers following their training, cutting the pie, getting with him, and then he's in the fatal funnel. That would have changed things. We can what if it all day long, but they're what ifing it, and they're asking you to make presumptions and speculate with Adrian, but they don't want to do it with anybody else. This is the hardest part of my job, because I have to sit down and I can't talk anymore. It's not that I like talking, I just have a lot to say. I get it. You can ignore me, you can say I'm full of it, that's fine. You can tell me after. But because the state has, the government has this burden that Jason went over, the highest burden in our justice system, the burden that the government has to prove to take away someone's liberty and change the course of their family's life and that person's lives. And it's a burden that we all agreed was appropriate for the government with all their resources to have. They get to go first, and they get to go last. They gave us that sandwich. They gave us the burden of proof sandwich, okay? It's the other way around. And so I have to sit down and I can't talk. And please give Christina your attention. And she's gonna make arguments to you. And you're gonna see me in the corner, and I'm not gonna be looking at her, but it's not to be disrespectful. I wanna give her a heads up. It's because I get frustrated because I wanna talk, and I got an answer, and I got a question, and I have an argument. That's just my personality, for good or bad. That's just the way God wired me, okay? But I'm gonna be looking down and be writing notes, and my legs are gonna be going 100 miles an hour. I already know. But you can ask yourself, not just what would Nico, Jason, or Gary say, but what did the evidence show, right? And I promise you, I'm gonna do my best not to object during her closing. I will try. She can do it. I'm not offended by it. I'll do my best not to object, but listen to her, okay? And we're gonna ask you now, I'm asking you to apply this burden, the burden that's the highest in our justice system, the burden that says not sure is not guilty, the burden that says, no, you can't take the person from the bottom of the totem pole and move them up and ignore all these things. You can't ask me to ignore all those things, government. You can't. You can't ask me to ignore all those things and apply this high burden. The judge told you in the charge that if you have a doubt and it's reasonable, one doubt, and it's reasonable, it's a not guilty. Just one doubt. Did they eliminate every doubt from your mind? I hope that's not the stand. If it did, then I'll deal with it. It'll be horrible, but I'll deal with it. But that would shock me, because that can't be the standard. That can't be the standard. That can't be the message, because she's going to come up and say, send a message. Well, but send a message also to the government. Send a message that, like Bill said in his closing, so we concentrated our case on the facts around Adrian Gonzales. Send a message you can't do that. You can't pick and choose. You've been given authority to steward well. People in our community say, steward this well, government. It's a huge responsibility. This is not how you steward it well. And if you apply the burden by law, if you buy the facts objectively, if you can acknowledge 2 things at one time, if you can acknowledge that families have been destroyed, because she's going to make an emotional plea to you. Everyone's cried, and you'll probably cry again. It doesn't take away something that my family's gone through or what they've gone through. If you apply them objectively and do what our founding fathers expected juries to do, we're asking you now, and we're hoping that you'll pick a 4-man or 4-person, 4-woman, and do a quick verdict, and a quick verdict of not guilty. Because the evidence is shown. He's not guilty, folks. Thank you, and God bless you.
State.
Thank you, Judge. I just wanted to, just a quick note that the judge is going to decide the punishment. I think that was made clear to y'all, but I don't know if it was confusing here with the closing statement. So I guess I'll kind of address quickly the idea that I bowed to political pressure. There's no evidence in this case that I bowed to political pressure. And I think if you remember in the opening statements, the defense talked about all these third-party investigations that went on in the opening. And the easiest thing would have been me to do what all those did, which is say, don't blame us, blame somebody else, or everybody's to blame, therefore you can't hold anybody responsible. That would have been the easiest thing. So, I've never bowed to political pressure. And that's not what this case is about. The defendant, in their opening statement, they talked to you about, and they did here in the closing, that he was not assigned to the school. He relayed information. He drove to the school. He went into the building. He called for SWAT. He stood perimeter. He evacuated students. He had no shields. He checked on another officer. He got the building plans. He secured a master key. And there was even testimony during the trial that he evacuated students, and wasn't that a good thing? A good thing. And he relayed information over the radio, and wasn't that a good thing? Ladies and gentlemen, this is not about doing a good thing. I am not standing in front of you. In this case, it's not been about handing out participation trophies. That's not what this case is about. This case is about, and it's always been about, holding officers to the duty that's mandated for them in the law. Mr. Turner and I, as prosecutors, we had these big books that we're supposed to follow and the laws and all that, and he described to you that there's a special law in these books. One special law with regard to children. And that's what this case is about. All of this, the personal attacks, all of that was an attempt to justify the unjustifiable, in my mind. We're not talking about people being perfect. We're not talking about pretzels. And I'm not here to send mixed messages. I'm here to say that when you are a peace officer for a school district and you raise your right hand and say, I am going to be a peace officer, I'm going to do my job, that you're going to be held responsible. You're going to be held to that duty. When we had the active shooter training that was brought in, that active shooter training goes through all the mass shootings of schools back to Columbine. At the time that the Robb shooting happened, we've had, 23 years of mass shootings. And school districts have begun their own law enforcement police force. That's saying, we're not just going to depend on the local police department. We're not going to depend on the sheriff's office. This school district, the Uvalde Independent School District, we are going to have our own police force. So what does that mean? That means these buildings, they are their homes. Those hallways, there are their roads. Those students in those classrooms, those are their people to protect. Even Mr. Gonzales, the defendant, says that in his video recorded statement to the Rangers. He says, it was a car wreck, but that's not my responsibility. That's the local PD's responsibility. But when I heard that there was a gunman and he was near the school and entering the school, that's when I got in and went, because that's his jurisdiction. That school district, that's his jurisdiction. Those students are his people. The charge that you have talks about the legal duty that the law enforcement is supposed to be responsible for. And then it talks about the Texas Education Code. And that's because our legislature had mandated that. And we cannot turn a blind eye to that. Their own expert witness talked about being in San Antonio and how he went into hot situations. Ladies and gentlemen, I would argue to you there's nothing hotter than a gunman in a school. That's pretty hot in my book. and we have training. And he said, if you have training or you don't, you figure it out. This defendant had training. He even provided the training. He put on the training. The defense would have you ignore all of that, all the things that they say that he did and that he's the low man on the totem pole. No, he's not. He's the top man. He was the police officer for the school district that showed up first. And why do we go back to having school police officers since Columbine? Because on any given day, you can have a monster that makes his way into your school. On any given day. On any given day, they would have you believe that because there was a wreck outside the school, that confused me. I don't hold me responsible because, the wreck's too much, so not my day. They would have you believe that on any given day where we have bailouts in the community, bailouts happen all the time. Even in large urban areas, you have people who outrun the police. But they want you to believe that because there were bailouts on this given day, but don't hold me responsible. Not my day, not my responsibility. They would have you believe that because he wasn't assigned to that particular school on any given day, don't hold me responsible. Not my day, not my responsibility. They would have you believe that because the doors weren't locked, it's not my responsibility. On that given day, the doors weren't locked, so not my day, not my responsibility. On any given day, I only had a pistol. He had a rifle, so it's not my day, it's not my responsibility. And then they would have us tell, the argument is because you had 3 other officers show up who believed that they were being shot at. Don't hold me responsible because on any given day, if you've got 3 other people that showed up, it's not my day, it's not my responsibility. And what strikes me so much in this case, and something that we believe the evidence has been brought to you that's going on, is the contrast in the training of the schools. If you think about it, since Columbine, the students have been taught, and you heard that, lock the door, lights out, be quiet. We are basically teaching these kids, and the kids in room 11 and room 12 were taught to practice for their impending death. You don't cry and you don't scream. But we're going to teach you what you do when a monster makes its way into the school. We're going to have you rehearse your own death. But yet, we have active shooter training that says to go to the fire that the defendant taught. But we're going to ignore that. Because on any given day, if he says, not my day, we're supposed to just look the other way. And I am sending a message. And I'm sorry if I'm repeating myself, because I want officers to know those days are over. We're not going to continue to teach children to rehearse their own death and not hold them to the training that's mandated by law. That when you hear the gunfire, you go to it. You go to the shots. You stop the dying, and you hold civilians, children, above yourself. You hold them, they're the highest priority of life. I think it's telling, and Mr. Turner touched this with you about the defendant's statement, and if you're going to get all the evidence to go back in there. He says in that statement, the teacher, she told me, he's over there, she pointed, he's over there, he's wearing all black. I think that statement is very telling because in that statement, he says on 3 different occasions, I walked over there. I walked to the school. I walked. And you contrast that with Miss Flores, and what is she saying? I ran, and I tell him, We need to get in there. We need to get in there. She's not saying you go. She's saying we. Because in her mind, I believe you can infer that those kids and the protection of those kids are still tantamount to her. And there's no evidence that she had active shooter training. There's no evidence that she taught active shooter training. She was just a teacher. So are we going to continue to hold teachers and students to a higher level of responsibility than we are going to hold police officers for school districts who raise their hand and say, I will be a police officer. Those hallways will be mine. Those children are my people. Those classrooms are my houses. I will protect them. Are we going to continue to do that? No. Because on any given day, you can be like Mr. Salinas and Ms. Torres, who came in and testified to you. They dropped their children off for school that day, and the next time they saw their children, it was at the hospital. Mr. Salinas told you that the child that he dropped off for school that day is not the same child he picked up. Because on any given day, a monster can make his way into an elementary school. Ms. Garcia testified that she dropped her child off at school, she went to the award ceremony, and her daughter wanted to come home with her. And she said, no, I paid $2 for that pizza party, you're gonna go and have a good time. And then she never saw her daughter again. Because on any given day, that can happen. We know that, we see it. Nueces County is not any different from Uvalde County. It's just not. What happened to Uvalde on May 24th can happen anywhere at any time. And if it's going to happen, and if we have laws mandating what the responsibility of a law enforcement peace officer is for a school district, then we better be ready to back it up. You had the teachers come testify to you about what was going on. And what do we know about what the defendant had versus the children in rooms 111 and 112? The defendant had his car. It was on the corner building. He had cover. What did the children have? They had chairs and desks. Defendant had a pistol. What did the children have in rooms 111 and 112? They had unarmed teachers. The defendant had a vest on. And what did the children have in rooms 111 and 112? They had curtains to hide behind. I would also, if you get all the evidence back, that you listen to the defendant's statement. And I think it's always telling, is when that ranger asked him, why didn't you engage? Why didn't you go and approach? And the look on the defendant's face is like, not me. Really? I mean, it's like he catches himself because it wasn't his day. On any given day that this monster made his way into Robb Elementary, that wasn't his day. You heard a lot about the time compression, the auditory exclusion, the fatal funnel, the OODA loop, the echoing. You even heard about a fatal field. Because we all know on any given day, there may be a fatal field. And we have to be ready. You're going to get all the evidence behind you, sent back with you, and you'll have the radio traffic, and you can look at that and decide if it's 1 minute or 3 minutes. But even a minute and 48 seconds, what he put up here, a minute and 48 seconds. I don't know if anybody just sat still for a minute and 48 seconds. That's a very long time to distract, engage, and delay. And his was right here. Was right here. All you had to do was to even attempt to distract, delay, or engage. I know this case is difficult, and it has been difficult. But we cannot continue to let children die in vain. We cannot. Oasis County is not any different from Uvalde County. We cannot let 19 children die in vain and another 10 to suffer. They're going to be that suffering for a long time. On behalf of those 19 children, I respectfully request that after your deliberations, that you return a verdict of guilty. Thank you.
Okay, ladies and gentlemen of the jury, you will have the charge of the court back there. You'll have the evidence. I will ask you to deliberate and give us the word when you have a verdict, and we will alert everyone and give time to get people back in the courtroom, and we'll bring you out and receive the verdict. We're going to have lunch served in the jury room for you. You're welcome to deliberate while you're eating lunch. And could I ask the three alternates to remain? We're going to have them go back, and I'll talk to you further. Okay? So let everyone rise for the jury.
Okay, Bree, what do you think about what we just heard?
Wow.
Okay.
Right? Wow. Obviously, I think, sort of Nico LaHood did a great job. What I think stood out for me about him is that he systematically went through the case and pulled out sort of all of the, pieces of testimony, all of the relevant facts, all of the timeline that directly attacked their indictment.
Right.
Right. And I think that that's, sometimes in the emotion of everything, we lose sight of the fact that criminal law is element based.
Right. It's elements of the offense.
Elements of the offense. You have to prove each and every element beyond a reasonable doubt. And so he systematically took the state's case and said, doesn't do this. He did act. He didn't fail to act. And then I thought it was super effective that he did the comparison between the other people that they didn't charge.
Salcedo, Coronado, Randy
Mendoza,
Hill, all these guys walking step by step what they did or didn't do, what they had access to, what they didn't have access to.
Right? I mean, I think that was really, really effective because it feels like their whole theme was he did act. Maybe, and I think, Tanya, you put it best. You said, maybe we don't like how he acted or specifically in what manner, but the point is that he did, and the charge is that he didn't.
Mm-hmm.
So I think we fall flat right there. Okay. And so now we have the elected that did the close for the state of Texas. And, I think they missed the mark, right? I think that, sort of you and I were talking about the fact that this case should have been very precisely about the elements of the offense that Adrian Gonzales was facing, not about all of the other, how many shell case. None of that really had, they could have really potentially presented a really, really straightforward case about whatever was specific to Adrian Gonzales. And I think that they missed the mark on that. And I think that her closing argument, didn't do it either.
And folks, I want to apologize for my voice. The allergies has taken it away. And so we have Bree West today as our legal expert. And again, I'm Tanya Eiserer. Normally my voice is much better, but not today.
We get glimpses. We get a little glimpse of
it comes
Tanya.
up and down. Yeah. I thought, what did you think about, you mentioned when the first thing she told the jury was that the judge was going to do punishment, and you made a remark about that. And you said, I want you to talk a little bit about that.
So from my perspective, that was highly inappropriate, right? I during jury selection, you don't even, if you're not going to a jury for punishment, you don't
Right.
even qualify them on punishment, right? Because you say to yourself, it's not even something that you have to do. They're told that in jury selection. I thought it was incredibly inappropriate that the state of Texas or the prosecution got up and said, oh, FYI, you guys aren't going to have to worry about punishment. I mean, that was just a totally inappropriate comment to come from, a little bit beneath the dignity of the state of Texas. I mean, it wasn't, that's just not something that's done in a criminal trial.
It's like, if y'all find him guilty, you don't have to figure out what he gets.
Right. And it's just, no, that's not, that's kind of not what we do. I think that just stand on your case. I get it. This is a hard case for the state of Texas. I think that the facts are really difficult and they're in a lot of ways not there. And so they're grasping at straws, but stand on your case. You decided to bring it, right? So don't have all of these other sort of ancillary, you don't have to worry about punishment when you find it. Yeah, I mean, all of that is just highly inappropriate in my opinion.
What do you think was the most effective thing that the defense did in their arguments?
Gosh, I mean, the most.
Mm-hmm.
I think that's. I think that both defense attorneys, they split their time, and both of them had a different style that I think had highlights, right? So I think that one of the things with the second attorney, Nico LaHood, is that he brought everything back to, I'm a real person that exists in the same communities that you live in. My kids go to school too.
Right.
And so the outrage, the sadness, the fear, everything that you have, I feel it too. So understand that where I'm coming from is from a human place, right? And so what I'm asking you to do in finding my client not guilty is not insane, right? Because I could do it too if I were sitting in your place. And so I think that was super effective to remind them that, like, this is not sterile. This is real. And then, he did some of the standard defense attorney things, right? Like, hey, if you didn't like how I questioned somebody, hold that against me. Don't hold it against my client. And I think that was important because I think that there were some people that thought he was a little bit aggressive. And so I think that I thought that was really good. But I think that the biggest thing with him in particular is that you were captivated by how he was telling the story.
Right.
And I think that made a gigantic difference if you just compare the two sides.
And my sense is always with trials that trials really are storytelling.
Yes.
And you have to tell a story.
And, we talk about this sort of in criminal justice, like who do you like more? Who tells the better story, right? And I think that has a huge impact on the way that a case comes out. Because, I've had juries after the fact come to me and just say, I hated you. I hated how you did this, or I hated how you did that. And so most of the time I come in second, right? So how are you presenting to the jury? Are you connecting with them? I think the defense did a really good job with that.
Now, was there anything in the prosecution's side that you thought was effective?
I think that they made a decision to bring a case that really it's very difficult to support with the evidence that they have. So do I think that they did a good job with what they decided to do? I think the prosecutor, the elected DA that did the close, I think that she did what she could, right? I do think that she was much more pinpointed. You could follow kind of what she was saying. I understood she was making global, public policy type of arguments and, all of that kind of thing. And I think that was with what they were doing, that was probably as effective as she could be.
Because it is a very difficult case because it is an unusual case. Now, if Adrian Gonzales is found guilty, okay, so if he's found guilty, what happens next? Walk us through what people could expect to see next.
So if he's found guilty, obviously that's kind of where the jury's job ends, right? So the very first thing that will happen is that the judge will release the jury and thank them for their service, because there's no part of the next punishment phase that they'll have anything to do with. And so But then the state and the defense go into a punishment trial. Now, whether or not that would happen today, it could be that everybody kind of just needs a little bit of a break if they were to come back with a verdict today. And so they may reconvene and regroup tomorrow. But essentially, both the prosecution and the defense would put on a full-blown punishment trial where you bring out everything that you want to. It goes in the same fashion as the jury trial, right? Prosecution goes first, they rest their case. There's opening statements,
the whole 9 yards.
There's closing arguments, right? Because everybody, you're still advocating, right, for your side, even if it's to a judge. Now, obviously, there are other circumstances where, say, the prosecution and the defense could come together and say, hey, listen, we as the state of Texas were satisfied. Do you want to reach an agreement on punishment if he were to be found guilty? That could happen too. If that's the case, then they would present that agreement to the judge to say, hey, will you accept this? And kind of save us all a little bit of time. So there's a couple of different ways that it could go, but regardless, the jury will be released and actually invited. The jury can then come into the courtroom.
Oh, really?
They're released from all of their instructions, and they can come and listen to the punishment case. They can talk about the case. They could give interview. I mean, they can do all of the things once they're released. So
I do have to, before we forget about it, we had Abraham Lincoln.
Yeah.
Thomas Jefferson.
Abraham Lincoln, Thomas Jefferson.
What'd you think about that?
I was now I have to say Lady Justice was great, but I thought in my mind, I thought that the defense absolutely pivoted on their feet to bring our response to Abe Lincoln. I that had to have been like, I think they Googled as they were sitting there to find a good quote. I mean, I thought it was hilarious, but the Lady Justice, I mean, that was a lot of time spent on kind of what the role is of the criminal justice system and the role of jurors in the criminal justice system. I thought that was, we had arrows, we had a definition of the blindfold and the sword and
their ability to like change on the fly.
Right. I think is the markings of a really great defense attorney. But I think that, I loved sort of the way that they have played off of the prosecution, the way that the defense has played off the prosecution has been nothing short of just, are there Grammys? Are there awards given? I mean, other than a not guilty or given out? Okay.
I don't think so. You've been a prosecutor.
I know. I mean, but this has been pretty outstanding. I mean, it has really been I think you said it. It's been a master class in how to try a case from a defense perspective.
Oh yeah. I mean, I've watched many trials in my career, and I have seen, and this is they definitely have done an amazing job.
I think so too. I think so too.
And, obviously a jury, they could talk to people about just what happens when jurors go back into that room. What happens? How does that go?
So, obviously, as much as I wish I could be chosen to sit on a jury. That's my dream. Mm-hmm. Nobody would ever pick me. I mean,
nobody would ever pick me.
Nobody would ever pick us. I think we would be really good, though. I think so.
I can look at the facts and evidence.
I think I could do that, unbiasedly. But so ultimately, you go back there. Most of the time, what happens is they sort of immediately pick a foreman. Right? They need some kind of leader. They need somebody that's going to say, okay, when we want to take a break and sending out notes and what evidence do we want? And so I think they generally will pick their foreman. Most juries then at that point, they go through the charge, right? Because they want to be reminded of what are we actually supposed to be deciding here?
Right.
We just heard, 3.5, 4 hours worth of closing arguments. We also had 9 days of testimony. Right? We need to just be reminded of what we're supposed to be doing. And so then once they do that, they start talking. A lot of times people take polls. The ultimate verdict is never going to be a poll, mm-hmm. right? The ultimate verdict is never going to be by chance or lot. But most of the time mm-hmm. they start by just saying, okay, where does everybody stand? What do you guys think? And I've seen verdicts come back almost instantly based on the fact that they didn't really have to have any discussion because everybody was on the same page.
Do you think that could happen in this case?
I think that what is likely to happen in this case, even if they go back there and they say we're all on the same page, out of respect for all sides, I don't know that they would come back as quickly as I think a lot of us think the verdict would come.
Well, I mean, and I would not find it unusual if they come back tomorrow morning.
I mean, I think we're on the same page about that. I mean, the over under on them reaching a verdict today but not announcing it until tomorrow, in my book, is really high.
Okay. For folks that might just be tuning in,
okay,
and I'm going to let you do this since my voice is really bad. Can you give folks the quick, like 5-minute rundown, 3-minute rundown of what just happened over the last 3 hours?
Okay. So today we came in. It was already decided and announced that we were going to do closing arguments. The things that were decided were the length of time that the state and the prosecution were going to be able to have in closing arguments. There were some last minute things that were going to be decided before closing arguments began, which I think, Tanya, happened off camera because they came in and the jury was walking in, but we also know that we were delayed. So we're not 100% sure about what that might have been. But what initially happens is that the judge reads the charge of the court, which is, hey, jury, this is now what you're charged to do, right? You have to make a decision on these 29 counts as it relates to Adrian Gonzales's guilt or not guilt. And then once the judge reads that, we immediately go into the closing argument. So the way that closing arguments work in the state of Texas is the prosecution gets to open the argument, which is what we call the open to the close. Mm-hmm. Sandwiched in between that is the entire closing argument of the defense. So the defense doesn't get to break it up other than between people. They don't get to go again after the after the prosecution goes or anything like that. And so sandwiched in between there is our closing argument, which we got to see I'm going to say defense attorney gold. I mean, it was really outstanding. And then the prosecution goes and closes the argument, closes the case. That's what we call the close. So what we saw was the prosecution opening the closing arguments, defense going. We did have a break, which we talked about that. We said, there's got to be a break. This is going to be 3.5 hours, 4 hours worth of just argument. So we had a little bit of break in the middle of the defense argument, which I thought was not terrible. I mean, I gave them a minute to regroup, and I thought they came back really strong. And then we had the final closing argument of the prosecution, and jury is now sent back to deliberate. It was as smooth can be in terms of how we deal. There were a lot of objections on the part of the prosecution in the middle of the defense closing argument, which I think in some ways is a little bit unusual, right? I don't know that we often see, if you're sort of secure and strong in your facts and in your case as a prosecutor, I don't know that you have to object a whole lot during the closing argument. It's not evidence. It's just the summation of the argument.
Okay, so I'm going to ask you to sum up the prosecution.
Oh my God. Can I? I mean, I don't, okay, I'm going to try. I think that in a weird way, I think that the first part of the prosecution's argument was sort of a KISS type of style, right? Just keep it simple. They had 3 points that they were trying to make as it relates to why Adrian Gonzales should be found guilty. He had the training. He didn't use the training. The children were in imminent danger, and he failed to act, right? And they felt like they didn't even need to go into a whole lot of detail about those 3 points. But literally, during the first part of their closing argument, those are the 3 points. They said, this is what our case is about. I mean, I think we can all sit here and say that we watched 9 days of trial, and it was really, that's not what you made your case about. Right. But that's what they said. And then they, make their public policy arguments. But then in the beginning of the state's closing argument, they spend like more than half of their time talking about what they think the defense is going to say, as opposed to just saying, this is our case, these are our facts, this is what we're going to talk about. They spend more than half of their time. So they talked about he had the training, he failed to act, and the children were in imminent danger. That's it. And then in their close, the elected DA, the prosecutor, said, we can't let, children die in vain. That was like the ending of her argument. And I sort of said,
nothing about what you guys said was what you presented during your case. I mean, yeah, we heard a little bit about training, but we really heard about the emotional aspect that this had on the people that lived it.
Right.
And I don't know that that's kind of the relevant parts of a criminal trial. So the summation of their argument is, I think, even though they didn't present it during the actual trial this way, that Adrian Gonzales had special training. Adrian Gonzales had special duties as it relates to the children. Adrian Gonzales knew what was going on. Adrian Gonzales failed to act, and Adrian Gonzales failed to protect and save those children.
Okay, so we've got Rebecca Lopez on the line. And so, Rebecca.
Yeah, Tanya. Well, obviously, the closing arguments I thought were very powerful on the part of the defense attorneys. And I felt like, and I agree with our expert, that it didn't feel like the prosecution wrapped everything up in a bow and handed it to the jury, like what they started with in opening statements and then in their closing arguments and then their witnesses and the testimony throughout the trial. I felt like they didn't kind of wrap it all up and hand it to the jury in a concise way that they could possibly render a verdict of guilty. Yeah, that's just my opinion from listening to all and then listening to all the experts. And I also thought it was really interesting. I've never seen, and Tanya, maybe you have, I've never seen a defense attorney play opening statements, recorded opening statements of the prosecution back in court and said, this is what they told you. And they didn't prove this. I thought that was very effective. I've never in my career, and I've covered a ton of trials, I've never seen them come back and play the prosecution's own words back in the courtroom in their opening statements to the jury. And I thought that was very powerful.
Yeah, Bree, go ahead.
Yes, Rebecca, I have called that a boss move. I mean, it was phenomenal. In all of my years, have never seen them be able to pivot. And that's kind of what Tanya and I were talking about. They are pivoting. That defense team is pivoting on their toes in a way that I don't know that I've ever seen. And I think that was a very powerful example of that.
Absolutely.
Yeah, and then I thought also the way that they outlined, they're telling you that he had to do this, and then that whole laundry list. And they said, if you've got one doubt about any of these things, then you have to render a verdict of not guilty. I thought that was powerful. And then obviously, I thought that, to me, a very powerful thing that the defense did was compare what Coronado, Mendoza, and Salcedo did versus what Adrian Gonzales did. Because if you do look at the actions of the officers, they're like, why is he sitting in this chair and these other officers aren't? Because they didn't go towards the action. They stopped and they set up a perimeter. And the video of them crouched behind the vehicle, and then the video of Salcedo training his weapon on what appears to be the shooter and not firing that shot, I think sit with the jury, because there were other officers out there that possibly could have stopped this tragedy, whereas Adrian Gonzales was on the other side and didn't see it. Now, maybe they thought, well, he should have run around the school and try to find the gunfire. But if you've got 3 officers and one with an AR-15 that's actually had his weapon trained on the shooter, and you don't take that shot, to me, I feel like that leaves a little bit of doubt for the jury, or a lot of doubt for the jury.
Yeah, I was going to say a lot. I think that is exactly sort of the crux of where things are, why is Adrian Gonzales the one that's sitting in this seat? Look at what these other 3 officers, what they were able to do, or how they were positioned, versus the person that's sitting here was literally on the opposite side of the building. I mean, if that doesn't raise reasonable doubt as it relates to Adrian Gonzales's guilt with what they've charged him with and how they've charged him, then I don't know what would. I really don't.
Well, and one of the things that they said in opening statements that they were going to show this jury is that Adrian Gonzales sat around and did nothing. He just basically stood by his car and didn't do anything. But the defense, I thought, was very good in showing, or very effective, I should say, in showing the jury Well, but he didn't just stand there. He's dealing with this frantic witness. He's doesn't for sure know at this point, there's a car crash. He thinks it might be a bailout initially. He's trying to figure out what's going on. He does call for cover, which is what they're trained to do. And then within 30 seconds, he's got a backup officer and they enter the school. They get shot at. They go into that fatal funnel. And but when you heard the opening statements and when they spoke to the jury during voir dire, it made it seem like Adrian Gonzales just stood around and twiddled his thumbs and didn't do anything at all. And I just don't think that that's what actually occurred. So it's an uphill battle, I think, for prosecution to get a guilty verdict here.
I couldn't agree more. I mean, I think that this is rough for the prosecution.
It's definitely a tough one. Rebecca, do we expect the families to come out today? Do we expect the families to come out?
Yes. I don't think the families are all kind of in the courtroom, and some of them went to go grab a quick lunch. Obviously, they're going to give the jury lunch, and they're going to deliberate during the lunch hour. But the families are expected, if there is a verdict today, they are going to set up a podium, and the families are all going to come out together and speak. Mm-hmm. And also, if there is an acquittal, Adrian Gonzales and his defense team are going to come out, and Adrian is expected to say something now. I think that he's very tormented also about what to say, because he does realize that these families have lost their loved ones. They've lost their children. They've lost their teachers, their sisters, and so they're, it's very difficult for these families. So I think that they're mindful of that, the defense attorneys, on if he is acquitted, what Adrian Gonzales should say that doesn't come off as, oh, woe is me, I was the victim here, because clearly the victims in this shooting were the 19 children and the 2 teachers that died and the 10 children that got injured. And then the impact and the effect that this had on an entire community, their families, their friends, on really all of us that felt the pain of these families. And so I think that they're going to be conscientious that if he is acquitted, that he will then come out and say something with his defense team.
Well, there really are no winners here.
There are no winners here. And I think probably what I would anticipate, if you'll remember the defense attorney that opened their closing arguments, he finished his portion by saying, these victims are not honored with an injustice committed in their name, right? And I think that that's a really probably powerful way to have Adrian Gonzales, if he's acquitted, say something and not make himself the victim and not sort of take attention away from the families that have lost here.
And what did you make of the fact that you had both sides saying you need to send a message to law enforcement? One side saying, if you find him guilty, the message is, well, you should just sit back and do nothing and don't go in, or you're going to be sitting here where Adrian Gonzales is sitting. So that's going to give officers a second thoughts about, acting right away. And then you've got prosecutors saying, well, you need to send them a message because they're going to be held accountable if they don't go into that school. So it's just such two different ways of looking at things. And I'll just be curious. I'd love to talk to the jurors after this to find out, when they reach their verdict, what persuaded them one way or the other.
I think that would be really interesting to hear from them directly. I think from my perspective, we're human. And I don't know that there's, the majority of humans don't view themselves as perfect. And I thought that it was really effective for the defense to say what you would be saying to police officers, to school police officers, is you have to literally be perfect. And if you're not, and if you don't do everything right, and if you don't make every right decision in the moment, then you're going to be held criminally responsible for being an imperfect human being. And I thought that was more effective, because I think that all jurors, all people, could put themselves in the shoes of somebody to say, man, I've certainly been in circumstances where I've not made, the best decision. I did the best that I could with what I had or knew. And so I think that was way more effective than sort of almost berating the jury to say, you better hold them accountable, and they better go in that school, and they better, sort of die.
in that, fatal fun. I just think I don't know that humanity is going to support that standard.
Right. Yeah, it's
and we do know that there was. I'm sorry, Tanya.
No, you go ahead, Rebecca.
I mean, do know that there was, once they did finally enter after those 77 long minutes, and there were a lot of failures by law enforcement here. And I think every law enforcement expert will tell you that these children and the teachers in there were failed that day. However, thought that it was very interesting that they're saying, well, but look, Adrian Gonzales can't be held accountable for that entire time, because at some point there was command staff that showed up, and then they did wait for those heavy shields, and the officers that finally did, the BORTEC team that did go in from the Border Patrol, did take fire, and one of them was injured. And even with the heavy ballistic shield, now could they have gotten those shields there quicker? I mean, I don't know why, but I felt like when we were listening and I was watching some of the videos, because I went through all of the surveillance videos and dash cam and body camera videos, I thought that they had heavier shields a lot sooner than 77 minutes. So, but they didn't bring that up, and they didn't show that some of those shields that would have stopped those rifle rounds were in that school earlier than the BORTEC team went in, but they didn't bring that up either side.
Which may in and of itself been kind of interesting. I wonder why that potentially wasn't a focal point. I just think like the entire timeline, at least on the part of the prosecution, that didn't feel like that was a huge focal point of their closing argument, which I thought was really interesting.
Right. Okay, Rebecca, we're going to let you go have lunch, and we're going to also have lunch. Thank you for joining us. And we will be back as we continue to watch. We'll be back when we hear with your questions or see a verdict. Thank you for joining us.
About when the prosecution said we need to send a message. We need to send a message to officers that they've got to act. They've got to follow their duty. They've got to distract. They've got to deter. They've got to engage, whatever. And then the defense comes back and says, well, but the officers who had a line of sight, who did not take a shot.
What about all these other officers?
What about all of the rest of them? So what the message you're sending to the officers is just stay outside the courtroom because, or out of the line of fire, or out of the scene, because then you have a better chance of not being prosecuted. I just don't know how that jury can think of those 3 officers with a line of sight to that shooter and hold them less responsible than Adrian Gonzales.
Sorry.
Yeah, I know. Tanya's got, she's been doing this for 9 straight days, and credit due, you've done a fantastic job, but it's taken a toll. Yeah, and I'm not sure, it could be allergies.
It's definitely allergies. And it's weird because it comes in and out. Like, okay, there it goes.
There it is.
And it's like a little bit like the little engine that could. If I get going, I'm okay. But again, okay, so we are seeing Nico LaHood, we're seeing Jason Goss, and we're seeing the other attorney in the courtroom. I don't yet see Adrian Gonzales yet.
Right.
And, we're just waiting. I mean, and this is the judge, from what we've been told, the judge has given everybody 15 minutes, time to gather in this courtroom. And you can, we're not seeing the images so much at the moment, but when we were looking at the faces of the families, obviously, they are very, this is hard. I mean, no matter where this comes down, this is hard.
100%.
This is a difficult thing I can't even imagine sitting in that courtroom and, seeing those autopsy photos, seeing those images of those children wounded. That is, and we didn't see them out here, thank God, because of, the way things were done. But that's got to change these jurors. But for the families, that's just got to be excruciating.
It is, and I think it's very difficult because it's so heinous. The whole situation is so heinous, and then America watched while 377 officers waited 77 minutes to breach that room. So it's horrific, and it's so huge. It's such a monumental a case, and this is a case of first impression in the state of Texas for the most part. But also, one of the things that you and I have talked about is that the state necessarily, I don't know if they necessarily focused on the actions completely of Adrian Gonzales. They were trying this as they were introducing evidence that basically bringing in family members.
You think they should have done a more linear presentation? Because, I sat and watched this day after day after day, and I'm like, where are they going?
Right.
There was a couple days where we had just a tremendous amount of testimony from DPS investigators about ballistics. And it felt like that could have all been condensed into maybe one witness.
Right.
And, for me, what was effective was when we heard, and I have to go back into my notes, there was something like 170 shots fired by the shooter, and the number of shots that were fired in room 111, and I'm trying to go back and look at my notes. It was a massive amount of firepower. But a lot of this stuff, I didn't understand, like, what story they were telling.
Well,
I struggled with that.
Well, exactly. I think that the fact that the shooter is dead, and they called him a monster. They were, nobody said his name. I don't know if I heard his name one time in this trial, because they weren't going to do that. They weren't going to give the shooter any notoriety whatsoever. So they would call him the monster. They would call him the shooter. They would call him whatever. But the fact that he's dead, that's not enough. If you know what I mean. I think that if it had been enough, we wouldn't be here today. So it was almost as if someone had to be held accountable for this massacre.
Well, and I still think it is debatable. I've asked every expert who came on throughout the trial, would we be here if the shooter had lived?
My opinion is no. We would be trying a shooter for the deaths of 21 people. That's what we would be doing.
19.
Well, kids, but then we murder.
I'm sorry, you're right. 19 plus 2 teachers. You're right. I'm sorry.
And then we could have capital murder charges brought
Absolutely.
against them. Attempted capital
murder.
Well,
and then you would have, of
charges.
course, the 10 children that got wounded.
Yeah.
I'm sorry, I got fixated on the number of kids that died because that's what he was charged in this trial.
Right.
Yeah, it's been strange to me. And then you have to wonder, what effect will this verdict have on Pete Arredondo, the former chief?
Right.
I mean,
Yes.
it's a different situation with him because he is the person throughout the majority of this incident that is calling the shots.
Right.
So,
Right.
what effect? I'm curious
Yeah,
what you think.
I think we're about to find out the effect that it's going to have on Peter Arredondo, Chief Arredondo, because I think if they come back with a not guilty, they may have to rethink it. They may go ahead and try him, but I think that they realize they will know. And by the way, the attorneys have the ability, if the judge, I know in Dallas, let me speak from Dallas, that oftentimes the attorneys can go in and speak to the jury before they leave. And I don't know if they'll do that in this case. I don't know. But it's sometimes helpful to understand what the jury's frame of mind was. And if the prosecution, whatever happens if they get a not guilty tonight, they may want to go in and talk to the jurors and find out what was lacking, what was missing.
Right.
And maybe then if they decide to go forward with the trial, then the trial's not set yet for Peter Arredondo. So, that's still up in the air, and I'm not exactly sure why. I think I've heard, but I can't remember exactly why.
I think there's some appeals going on related. I wouldn't claim to know all this, but there's some appeals related to him trying to get information about the Bortak team.
Okay.
That was the group of people
right.
that ultimately made entry. But it has something to do with that. And now again, his situation's different because he was the chief and he was the person calling the shots. He's the person who tells Gonzales to go outside when the radio's not working to make the call for TAC. So there's a lot more, in my mind, culpability.
Right.
Because there's, command authority, he's the chief.
Right.
And when you've got those stars on your collar, you have more responsibility. But this is extraordinary because this is a rank and file officer being tried in the state of Texas under this statute, the first case we know of tried in this way. And, I have to wonder, though, of course we don't know, but could they have done a more linear job telling the story of the prosecutors?
Oh, yeah, without a doubt. Just, and you trying a case is all about the story.
Right.
It is all about the story. Sure, there's dry testimony that you have to bring in certain cases. But again, I'm like you. Why the expert to talk about the ballistics in every cartridge that was found? Or I don't understand that. I don't understand that. And so, yes, I think that it felt like the car was swerving all over the road.
Yeah, I couldn't. I mean, I felt like actually on day one, and I wonder if this is part of it, on day one, for folks that are joining us, we have been told that they have reached a verdict, that the jury has reached a verdict. They are waiting for everybody to gather in the room. You can see family members back there. I actually also see Rebecca Lopez there in the courtroom waiting for the verdict. We saw Adrian Gonzales' attorneys had entered the courtroom. When we saw the shot up a minute ago, I didn't see him having entered the courtroom yet.
No.
But, this has been a hard-fought trial for everybody.
Yeah.
This has been, no matter what happens, it doesn't change the tragedy of what happened here.
I think what we saw were some very incredibly brave witnesses. We saw people who were direct victims of this event, and they got on that stand and they testified, and you can actually see the physical damage to the teacher.
Oh yeah, the guy
at 111,
his hand, he got shot in the hand. Oh my God!
You could see it, and oftentimes when we had a witness on the stand, unless it was a law enforcement officer, we didn't even see their faces.
Right.
The jury certainly saw all of that. They saw photos of the room where the children died in 111, 112. They talked about just the devastation in that room. We didn't see that. If you're in that courtroom and you're sitting on that jury, you don't forget those images. And I think one thing the prosecution did, and here comes Adrian Gonzales. One of the things the prosecution did do is he never wanted this not to be about the children.
Right.
So they emphasized, here we go. Looks like something's going on.
Okay.
And maybe bringing in the jury.
Please be seated in the courtroom. Members of the jury, I've received information that you have a verdict. Could I have the presiding juror stand momentarily? Is that verdict unanimous, sir?
Yes, sir.
As to each of the 29 counts?
Yes, sir.
Could you hand it to the bailiff for me, and you may be seated? Could I have defendant and counsel please rise? All right, your cause number 25 FC 0001U, the state of Texas versus Adrian Gonzales. In each of the 29 counts, we, the jury, find the defendant, Adrian Gonzales, not guilty. You see it? All right, members of the jury, I want to thank each and every one of you for your close attention and your patience and being with us timely throughout this trial. I know it was not easy for you. I know everybody was drafted. Nobody volunteered. It was a long endeavor, and I want to thank each and every one of you for being here. I'm going to ask you one more time to go with the bailiff to the jury room, and we'll release you from back there. But thank each and every one of you, and would everyone rise for the jury to be excused? All right, Mr. Gonzales, you were acquitted by the jury. Your lawyers can talk to you more about this, but you do have the opportunity within a timely manner to file for that expunction. They will tell you further about that, but it's incumbent on me to tell you that immediately after the verdict is returned. All right, we're in recess. Thank you very much. I'm going to tell them, folks, it's up to you. They're released from their instructions. I'm going to tell them that, and then I'll let them.
Okay. Okay, so there you have you have it. Not guilty.
Not guilty.
And so much emotion in that courtroom from the family, from Adrian Gonzales. What's your reaction, Terry, to what we just heard?
Well, I think it's a correct verdict. I think there was ample reasonable doubt that Adrian Gonzales endangered those children per the indictment.
So what's previous instructions, I told him the lawyers may want to talk to him. It's a target.
Okay. Hold on.
Well, Emily, wonderful job.
Thank you. Thank you for the gift card. That
Should have been more. I didn't realize it was going to be. But no, I guess, as I was telling that, the good news is, under Trump, the IRS doesn't tax overtime, so we don't get it. We don't get it. That's what I can say.
I don't know.
Bill, wonderful job. Thank you. Pleasure to meet you.
Well, we'll just continue to listen for now.
Living in San Antonio now, where are you at?
Around Dripping Springs.
Oh, okay. I knew you weren't up Brazos anymore. Bill Uvalde for the food, as we will, but maybe somebody tomorrow. It'll last tomorrow. Somebody will take it.
Yeah.
Seeing a lot of emotion in that courtroom.
Oh, yeah, right. Yeah, and I hear the judge talking to someone. What they'll do, Tanya, is they will release the jurors basically before they release others in the courtroom, most likely.
Open the door and say who wants it, and it'll be just fine.
Thank you. Wonderful job. Oh, they're very good.
Okay. Yeah.
Okay.
So it looks like now Adrian's left the courtroom, and I see one of his attorneys still in there. I hear the judge. Basically, I don't know if the judge is going to address the families in the courtroom. I don't know. I know Rebecca Lopez is there, and so she's going to have some insight on this. But
And then we are expecting press conferences after this.
okay, yeah, right. And the family, as you can see, they're seated there for a reason, and I'm not exactly sure what it is, unless the judge maybe is going to talk to them. You know, this has been exhausting for these families, and I think that may be part of what we're seeing too. I can't weigh in. I can speculate whether or not it's disappointment. But certainly heartache. It's certainly exhaustion.
Oh, I can't even imagine being these families.
Right.
There's something weird going on. I continue to write them saying, like, hey, what's going on? Like, I updated with that. By the way, just expect there's a few more things going on.
Okay.
There's supposed to have a.
Okay.
My recollection is the legislature put a time limit
Okay.
to dispose of cases.
I thought so.
Well, we can.
That's why I'm going to be right.
We can.
I don't know if you have any suggestions. I'd like to hear.
Okay, so Terry, what's your reaction here?
Okay, so we have a not guilty. I think I think the probably the most effective argument was, can you hold this man accountable and not hold 376 other officers accountable? That he's the low man on the totem pole. He did act, and you can't look at it in a vacuum. You can't look at it, well, he did drive up once he heard there was a shooter at the school. And then, yes, he did run into the school, but it was that minute and a half or that period of time in between that he didn't do what he was supposed to do, is what the state was claiming. And the defense is saying, no, you've got to look at it in the totality of the circumstances. Basically, he did drive up into a situation. He did not know what was going on. He didn't know if he was driving up to the shooter, that if it had been the shooter, he could have hit him with his vehicle. I mean, basically that was implied. So it wasn't that he didn't do anything. He called in on the radio. There are so many different things that occurred with the dispatcher not being able to relay the information that they needed to relay, that the fact that the school doors didn't lock, they brought that into closing argument, that there are a lot of things that could have happened that might have also kept these children out of danger, that the officers that did run into that hallway, into the fatal funnel for the most part, if those doors had been locked, then maybe they could have encountered the shooter in the hallway. So I think the defense was trying to say it's not just the action of one officer that caused the injury or the who endangers these children. It was a variety of things. That one thing I think that I would have mentioned had I been the defense, and I believe I heard this correctly in testimony, is that the special ed teacher, she stopped the kids from coming out of the south wing, which is the 4th grade wing. She stopped them from coming out, and then she did say that she thought the shooter had gone in that south door. Well, that is the door that Adrian Gonzales went in. He went into the south door. So as far as he may be thinking is that he was following that shooter right into the school, but he had to do a few things in the meantime to get some information, figure out what was going on. Okay.
What about Peter Redondo?
Yeah, I think you're right. Tanya's asked, what about Peter Arredondo, the chief who has been held responsible and for being the chief who should have been in charge.
Right.
We heard testimony that the person that should have been in charge was the school resource officer chief, and he did not take command.
Right.
He didn't take charge. He didn't have his radios. He had left them in his car or at home or in the station or something. He did some things that you would expect a chief of a division to act in a different way. Now, Adrian Gonzales, like you say, he was a low man on the totem pole, and those are not my words. Those are Nico LaHood's words, that he was a low man on the totem pole, and he was doing what he thought his training taught him, and that he was following what his training was. He was trying to ascertain what the information was coming in, and he was trying to figure out where the shooter is. And in a minute and a half, that shooter was in the school.
What do you think? What do you think happens now to Peter Redondo's case?
Well, I this is what I think. And what Tanya asked is, what do you think is going to happen to his case? His case is supposedly, he's been indicted. His case is going to be set for trial. And I personally think they will try him. I think they will try him. They have seen exactly how to try this case now. And he has a completely different responsibility than Adrian Gonzales. And I think they will definitely try him. I think they will look at this case and say, okay, I'm not sure I'd call Officer Hill with his Someone, what they'll do, Tanya, man on the totem pole, he did act, and you can't look at
towards Adrian Gonzales, somebody accountable. I'm sorry, I thought you. So there has been pressure from the families.
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.